Greetings, greetings. Good morning, ladies and gentlemen. This is the Stock Market Live with LCAOD, and it is Wednesday, March the 23rd, 10:24 a.m. First off, I want to give a huge shout out to my brother, man. Happy birthday! Today is his birthday. Happy birthday, bro. Love. Yeah, ladies and gentlemen, the market has been open for about almost an hour now. Very chill day here. I had some meetings this morning. I'm starting to feel like a politician, man. All these little last minute meetings, they last in the mornings, but now they worth it, man. Just some consultation with some clients and things of that nature. Um, the market is chilling out here. It took a little dip, but it's looked like the rally is about to begin here again. Um, I think the hearing might be causing this right now. There's a lot of news. Powell spoke this morning. He probably tanked it this morning, and it looks like it's picking back up. Don't know what he said. Can't quote him yet here. Just getting started. But we're gonna get all the information we need to get up here, man. Shortly. Shortly. But I hope you guys had a good night last night. I hope y'all have a good morning today. Good day today. Um, and really just kind of just like want to learn something today. Keep your ears open. Keep your eyes. Keep your ears open so you can hear. Keep your eyes open so you can see, man. So really chill today. I think we got some Fed speakers going on today, but nothing really too big. Another chill day, kind of like yesterday, but it look like the Bulls can take advantage of these type of chill days if they want. As of right now, ladies and gentlemen, Tesla's on the high here. Tesla's on the high. They just rocketed up. And it's crazy. I just literally was just sitting here looking at the premiums, hesitating to buy, and it just took off on me. They still got room to run, though. They're breaking resistance here. Tesla new resistance is probably about 1040. If they break 1040, you guys, it's going to 1080 today, or maybe by Friday. It already broke 1020 resistance here, but it looks like it's wanting to backtrack it now. It might not. It might be support right there at that 1025. Amazon right here is still below 3,300, so they still not broken out yet. Still trying to give people a discount before they do, maybe. Amazon still, I think, want that 3,350 by Friday, maybe, possibly. I'm hearing 3,400, but I think 3,350 will come first here. So just keep your eye on Amazon and Tesla, man. That's really who been moving the market here, paying people. So you just keep your eye on them. Google's down here. Just trying to give you guys a quick little skim through here before I get into the disclaimer. I don't want to go over any more news here. So what we're gonna do first? Let's go ahead and read the description here. Live coverage from the stock and crypto market. Live ideas of thought and studies. This is not financial advice on this stream or with this company, ladies and gentlemen. With that being said, this is the Stock Market Live with LCAOD. As you can see, the indices are in the red here. The Dow is down 63%. We got the Nasdaq down about 45, 50. The Nasdaq is down about 54 actually. So the S&P 500 is down 50. The Russell 2000 is down about 1.18%, and the VIX is up here today at $23.28, up about 1.48%. So yeah, the main names took off yesterday, and the Russell 2000, AMC was on the high yesterday, and GME was on the high yesterday, but it looks like they cooled off here. Well, not GME. They're kind of like holding a little bit of their gains, wanting to break out. Just haven't did it yet. You can tell. AMC actually kind of broke out to the high, but wanting to break out didn't do it yet. You can tell. These are pretty good plays, man. AMC and GameStop. I would be long in these. These are meme stocks. People like to laugh at them, but they really can pay, man. It's like one of those stocks that you laugh now, laugh to the bank later. It's a meme stock, you guys. They can really run, have short squeezes and things of that nature. AMC, remember they short squeeze last year to 60, and GME short squeeze to 500 last year. So keep that in mind, man. These stocks can really run. They really pick up here. But right now, it looks like we're getting a real big discount. Nothing's on the high besides Tesla. Tesla is leading the way today in the market, you guys. They're up $33, up about 3%. They had the implied move on them. They just really just going still, just keeping the continuation. You got to think, ever since their earnings, they've been oversold, so they kind of deserve this now. You can't really stop a moving train. Um, keep in mind here, big tech is getting clapped too. So that's looking the most attractive now, big tech, because they've been getting clapped so much. So now you got a lot of investors, they want to buy into it, see what the hype is about, and see what everyone talks about. Why everybody talks about big tech the most. I'm pretty sure people are understanding now. If they brought the dip here on any big tech name, you're extremely up right now. Um, so just keep that in mind here. But it looks like Tesla is holding that 1020 support there. It was resistance, looking like it's supporting now. So this can really rally, you guys. Tesla can really, really rally here. Um, keep in mind they already are. They already are. They gave you a discount this morning, and that was about it. And market's going up here. So far, the SPY's up here above VWAP just a little bit. We're back above 446, so the market should remain bullish here. It looks like we're really entering a bull market too, you guys. Like, things have really reversed. The bear market is really over with, especially after these first hour. This first hour, excuse me. Yeah, I would say the bear market is definitely probably done here. Now, I'm not saying that they're not going to start taking profits and people are going to start making a dip, selling. Of course they are. But what I'm saying is the dip is going to get brought here. It looks like from now on. I don't really see us going back to the 3-month lows. It'll take a lot of bad news here for it to happen. So that'll be like Tesla coming back down below 700. I don't just see it anymore. I don't see it anymore. If anything, I can see Tesla coming back to maybe 980 as of right now. That's the slightest pullback they'll probably give you here if they only gave you 976 this morning. So keep that in mind. Right here at trying to get to that 1040, you can tell now once they break that resistance, the next level would be about 1055 or 1080. 1080, like everybody's saying. So you break 1080, then it's off to 1100. But yeah, that's another thing for Tesla, man. They just been on a run, man. They just been on a run. They're really short squeezed. It's basically a lot of people bought puts, and they're paying that cost now by having to sell for a loss. Because Tesla's just going up, man. It's just going up. It just has been since March 15th. It just hasn't stopped going up since March 15th. So this rally is really cool of Elon to be doing here, considering the type of person he is. Um, he doesn't really. He's just kind of like anti-government, and he's really helping the people right now by doing this. And I think he knows that. I think the people know that too. The SEC, the government knows that. So they just kind of like play like they don't. But yeah, man. Shout out to Elon Musk, man. They must we trust. It looks like the confirmation hearing is the only thing that's worth it here right now, pulling up. So we're gonna get into the confirmation hearing. Haven't did anything today with my portfolio in my company yet. Just watching here. Still got some things I'm holding here. A couple things. They're just really kind of holding their gains. Tesla's picking back up here. Amazon is green now, 3,300. So it's looking really, really bullish over there. Amazon, they just now waking up here. Tesla's your leader now, but remember, Amazon can just easily become a leader as well. Tesla is going here though, trying to break that high 1034, and it looks like they're going to try to retest 1040. Is going to be your next resistance there on Tesla. So the SPY is going up. It's causing the stocks to pick back up. So the dip was brought again, you guys. We brought off support here again at 445 on the SPY. And the Dow, they brought off 344 in the triple Qs, it looks like. They brought off a 352 here. So the Dow drops about 200 points as oil prices rise. That was the headlines from this morning. So now the Dow is reversing here. Oil prices are really not rising. So that's a cap headline. So just keep in mind what's going on. It's just the media trying to trick you here, trying to cause you to overthink. But yeah, man, the oil prices ain't even really that high. They high, but they not high like they was. You know what I'm saying? Like on no crazy shit. So ladies and gentlemen, yeah, man. It's 10:34 though a.m. We just now getting started here with LCLD. If you're tuning in, we just now going live here. Missed the first hour, but nothing we did really miss. Nothing really going on. It was really basically there was a dip during that first hour here, and then about 30 minutes later, the market picked up. So far, we're just right here, looking like this might be resistance or this might break out here, ladies and gentlemen, to the upside even more. So we're gonna see here shortly, but right now let's focus in with the hearing. This day 3. I think they're about to be done after today with all of this Supreme Court nomination hearing stuff. But that is live right now. So let's tune into that. That's the only thing that's live. And this is day 3. So let's tune into that. And I think this is the last day for this hearing. It already started this morning. Powell already spoke this morning. I'm going to try to find some quotes and see what he said later on. I think he was saying some things of I think even Bullard said some things like Bullard said he favors Fed rising rates, stocks as inflation's hedge is new catch. So they basically from my understanding they're trying to say the stocks is good for inflation. So just keep an eye out on what they mean by that, you guys, and just stay cautious, stay patient. Good luck to you today. Yeah, let's get it, man. Let's get it. We're about to tune into this news right here, and we're live here, ladies and gentlemen. This is the Stock Market Live with LCLD. Let's see what they're talking about here. 10:36 a.m. Like I said, running 1 hour late today, but like I said, when you're late, you're on time here lately, and when you're on time, you're late here lately. But I had some meetings, some consultation meetings here with some hopefully maybe new clients, possibly soon. So that's what caused the delay. I do apologize, ladies and gentlemen. Things like that happen, not often, but every now and then. So yeah. I do apologize, but we're here now. This is the Stock Market Live with LCLD. Let's continue to listen to Brown Jackson Supreme Court confirmation hearing, and this is day 3, and we are live. They have already started this about 95 minutes ago, so we're going to just tune in now where we at. Market picking up, Amazon picking up.
A habeas petition, especially early in the process of the response to the horrible attacks of 9/11, lawyers were helping the courts to assess the permissible extent of executive authority by making arguments. And we were assigned as public defenders. We had very little information because of the confidentiality or classified nature of a lot of the record. And as an appellate lawyer, it was my obligation to file habeas petitions on behalf of my clients.
Thank you, Judge. I'm going to try to set an example by yielding back about 7 minutes of my time. I invite my colleagues to follow that example if they wish. Senator Grassley, you're next.
Yeah. Before I start, I'd like to make a brief point. Yesterday, Senator Durbin referenced Congress's effort to stop child pornography and the exploitation of minors. I've worked on this issue for decades. In 1983, I supported the Protection of Children Against Sexual Exploitation Act. In 2012, I sent a letter to the Sentencing Commission while Judge Jackson was vice chair. In the letter, I encouraged the Sentencing Commission not to lower sentences for child pornography. I said that, quote, it would be a disservice to the American people to have the commission issue a report that advocates for the reduction in sentencing for a class of criminals who cause profound and lasting damage to their victims, end of quote. I'd like to have that put in the record.
Without objection.
Yesterday, you referred to your record of decisions as the best thing to look at when explaining and evaluating your nomination. But you also said that you haven't had enough cases involving constitutional law to develop a judicial philosophy. If you haven't had to develop a philosophy for deciding cases yet, what else do you think would be helpful for us to look at?
So respectfully, Senator, I do have a philosophy. The philosophy is my methodology. It is a philosophy that I have developed from practice. Unlike some judges who come to appellate work from academia and who have some overarching theory of the law, I approach cases from experience, from practice, and consistent with my constitutional obligations. So my philosophy is one in which I look at cases impartially, consistent with my independence as a judicial officer. I understand my limited role in the constitutional scheme and therefore take very seriously all of the constraints on the exercise of my authority that exist in our system. What that means is that at the beginning of every case, I am setting aside my personal views.
That's the three steps you gave us.
Yes, sir. Yes.
So you don't have to go into that. Let me go on then. Should the Supreme Court overrule a precedent when it is clear to the justices that the precedent was wrongly decided?
Thank you, Senator. Stare decisis, which is the principle that the Supreme Court uses at the outset. It's the sort of background rule of judicial maintenance of precedents in order to have predictability, stability in the law, is the kind of principle that the court begins with when it is asked to overrule or revisit a precedent. And the court has developed certain factors that it looks at before it actually undertakes to reverse a precedent. One of those factors is the view that the precedent it's reconsidering is wrong, but that's not the only factor. The court also determines, in addition to whether or not the prior precedent was egregiously wrong, the court has said, the court looks at whether there's been reliance on that prior precedent, whether the precedent is workable or has proven workable over time, whether the cases in the area of the precedent have shifted such that the precedent itself is no longer on firm foundation, and whether there have been either new facts or a new understanding of the facts that give rise to a need to revisit the precedent. So it's not just a look at whether or not it's wrong, and it's important that the court take into account all of those factors because stare decisis, meaning letting the precedent stand, is a very important pillar of the rule of law.
When is it appropriate for a judge to impose a sentence enhancement under the guidelines?
Thank you, Senator. The federal sentencing guidelines are crafted to assist courts in making sentencing determinations within the broad range that Congress prescribes for cases, for crimes. So in the typical case, a defendant is convicted of some crime. In the federal system, they're usually very serious crimes. And Congress will say, Judge, you can give that person a sentence anywhere between 0 and 20 years, for example. The sentencing guidelines are designed to set out a series of factors that judges should be looking at when they decide what they're going to sentence that particular person to. And those factors will be things like, if this is a violent crime, does the person have a weapon? If this is a violent crime, was there any injury? And so the judge is looking at these facts, in many cases horrible facts, and calculating the guidelines based on what we call enhancements. Each one of those different characteristics or conditions is an enhancement. So you ask, when is it important to when it's appropriate? Well, the judge has to calculate the guidelines in every case. That's how we start the process. But under the statutes, in addition to calculating the guidelines with all of those enhancements, the way our system now works is you determine what the guideline range of punishment is going to be. And then Congress says you look at a series of other factors in addition to the guideline range. And at the end of the day, the judges in the system now are choosing sentences based on both the consideration of the guidelines and also the consideration of the statutory factors that Congress has put forward.
Have you ever declined to impose an enhanced sentence on a defendant because you disagreed with the enhancement as a policy matter?
Thank you, Senator. Yes, and the reason is because of Supreme Court case law concerning the way in which the guideline system operates. The Supreme Court has determined in a case we discussed yesterday that the guidelines are no longer binding on judges, meaning the guidelines you calculate, but you don't have to stay in the guideline range anymore. That was the Supreme Court's Booker case. And I can't remember if it's in that case or in subsequent case law, but the Supreme Court has also made clear that when you are calculating the guideline range in the new system that we're in right now, judges are free, the Supreme Court has said, to decide in particular cases whether, as a quote unquote policy matter, they disagree with a particular enhancement. That is the state of the law. That is what the Supreme Court has said judges are permitted to do in cases. And so I have, in certain cases, given the way in which the guidelines are operating, the disparities that are created in cases, I have at times identified various enhancements that I have disagreed with as a policy matter because the Supreme Court has said that that's the authority of a sentencing judge in our system.
Are nationwide injunctions constitutional?
Well, Senator,
You've issued them.
thank you for letting me address that circumstance. The reason why I paused is because what I have issued is not technically a nationwide injunction. People call it that, but in a particular set of cases, administrative agency cases that are brought under the Administrative Procedure Act, these are challenges to agency actions, like agency rules that they have promulgated. And if the challenge is to the procedures that the agency undertook to create the rule, the statute that applies, the Administrative Procedure Act, tells the court that if you agree with the plaintiff that the agency rule is faulty procedurally, the remedy in the statute is to invalidate the rule. That's what Congress tells judges to do. Now, technically, that's not a nationwide injunction. That is invalidating a rule that the agency has enacted. It may have nationwide effects because the agency may have implemented its rule nationwide. But what the court is doing is not reaching out and touching everyone in the country. The court is directing the government that has promulgated that rule that the rule is invalid. And that's what the statute tells us we have to do in those cases. That's different than a nationwide injunction, because a nationwide injunction would be a situation in which we're not dealing with the rule, we're not dealing with the Administrative Procedure Act, we're dealing with a particular case in which something has happened between the plaintiff and the defendant, and the court says, based on what happened in this case, I'm going to tell everybody in the country that you can't operate in this way anymore. I'm going to find on the basis of this particular case, and I'm going to enjoin everyone in the country not to do that anymore. That's a nationwide injunction, which is not what I've done in, I think, the cases that you're talking about.
How can the judiciary address concerns about forum shopping, given the rise of nationwide injunctions?
Well, forum shopping is a concern that arises when litigants seek to go to different places in the country where they think that they may get a better result. And it's something that Congress can address, because Congress has the power to determine various aspects of judicial process.
Explain the political question doctrine, and then what standards would you apply to determine whether a claim before you implicates a political question?
So the political question doctrine is a doctrine that relates to the jurisdiction of the court. As I mentioned, the courts are in a particular branch of government, the judicial branch, that is limited in its power. The courts can't make policy. They can't reach out into the world and decide that certain things are good or bad and then address them. They have to wait for cases to come and decide them. And when a case comes, it has to be presenting a question of law for the court to answer it. If a person comes to the court and they ask the court to answer something that is properly in the province of Congress, if they ask a political question, then the court has to say, I'm sorry, that's not my role. So I had, for example, a case that involved Yemeni citizens who, I'm trying to get the facts exactly right, but they had relatives. I think they were resident in the United States, and they had relatives in Yemen, a war-torn area. This is a few years ago, and they came to the court, me, asking if I could direct the administration to extract their relatives from Yemen, that they wanted me to order the executive branch to send in troops and get their relatives out, because it was obviously dangerous for their relatives to be in that country. And what I said in that circumstance is, essentially, I don't have jurisdiction to do that, because what you're asking me to do is a political question. The question of when and where troops can be sent and who can be extracted from foreign governments belongs with the executive branch. And so you have to ask them. And so I said I have no jurisdiction. That's a political question doctrine, and it's well established in our law.
Yesterday, in response to a question from Senator Durbin, you said that as a judge, you are, quote, trying in every case to stay in your lane, and end of quote. That's the same time you gave us the 3 steps you go through as you work yourself through a case. You also described the text of law as a constraint on your authority. But in several cases, I'll list Make the Road New York, AFL-CIO versus Trump, Watervale Marine Companies, and others, the DC Circuit reversed your decision or criticized your reasoning for failing to follow a clear and unambiguous text. Why didn't the clear text of the law constrain your authority in these cases?
Thank you, Senator. You mentioned 3 cases. Certainly with respect to the second one, the DC Circuit didn't say that the text was clear, and in fact, that's what happens in cases, that judges at the trial level do their best to make interpretations. In that case, it involved a channeling provision. This is AFG versus Trump. It involved a provision, a statute that was designed to channel the judicial authority into an agency. And I interpreted the statute, and I thought the arguments that were being made, the claims that were being made, were not ones that Congress had intended to channel. And I went through the analysis, and I explained my reasoning as to why I thought I still had jurisdiction, and I went on to address the merits, which is the duty of the judge if they determine they do have jurisdiction. The DC Circuit disagreed. They wrote an opinion that interpreted the statute differently with respect to those claims, but it was a case of first impression as to what those claims meant and whether they were supposed to be channeled or not, and that happens. The district judges do their best, and sometimes the Court of Appeals and the Supreme Court haven't spoken to the issue, and the parties disagree. In Make the Road, I explained that what I was attempting to do in light of Congress's enactments, not only the particular immigration provision, but also the Administrative Procedure Act, was reconcile the statutes of Congress, which is something that the courts also are supposed to do. That there are statutory interpretation canons that make clear that courts are supposed to understand that Congress intends for its statutes to work together, and to the extent that you are interpreting and the claim is made that allows you to do that, that's the sort of way in which interpretation is done. I can go through my actual analysis. I did it yesterday as we talked, but there was a good faith disagreement between me and the Court of Appeals, which gets to decide as to what the language meant and whether or not Congress actually intended to exclude the APA using that language under those circumstances.
Thank you very much.
Senator Leahy?
Thank you, Chair. And welcome back, Judge Jackson. I know yesterday was a grueling day of questions. I commend you for your poise, your endurance, your thoughtful answers. I felt privileged to be here for hours of that, and you had even more hours. But I want you to know the reaction in my own state of Vermont. I've gotten all kinds of emails and calls and from friends across the political spectrum. They're all been praising you. And they said they realized that a lot of the questions that were lobbed at you had nothing at all to do with your qualities as being on the Supreme Court, but were some members unfortunately aiming for what a soundbite that they might be able to put on a political website where it now is. For example, we heard some overheated claims yesterday that your representation on Guantanamo detainees somehow signaled your policy preference with how the United States has dealt with those detainees. Every single member of this committee, especially those of us who have been assigned as counsel in cases, should know better than to complain of nominees' past representation of their policy positions, or to argue that a nominee espoused their client's viewpoint simply by choosing to represent them. So, your policy views aside, can you reiterate why it's so important for our courts to have the benefit of the best possible legal representation on both sides of any case, and especially in cases where we are in uncharted legal and constitutional waters?
Yes, thank you, Senator. So I've been a judge for almost a decade, and what I've learned is that as part of my duty to render decisions consistent with my judicial oath in support of our Constitution and the rule of law, I need to consider all of the arguments related to the dispute that is being brought in my courtroom. I need to hear from not only the parties who are prosecuting a case, for example, a crime, but also from the defense. And some of these crimes are terrible crimes. Our Constitution is designed to ensure that the government affords due process to people who are being accused of crimes. And one might think it's even more important in a way in a case in which someone is so reviled. It's kind of like the First Amendment. It's a protection for unpopular views. It's needed when there's a chance that the government will suppress or do something that's untoward. And so in the criminal justice system, we have many, many amendments that are designed to make sure that unpopular people who are accused of doing terrible things, are still treated fairly by the government. And that's a limitation on government power, which is the framework of our Constitution. It is about limiting government overreach. And so in the criminal justice system, you can imagine, and the framers imagined, a world in which the government would use its authority to deprive people of their liberty, to throw people in jail, to lock them up and throw away the key, to not give people the opportunity to make arguments about their freedom. That would be a real exercise of government power, government overreach. And so the framers said, what we're going to do is we are going to put in our foundational documents a protection for people that the government is accusing of crime. And that's not to say that the people are innocent. That's not to say that they haven't done terrible things. What it's about is ensuring that the government does what is required in order to ensure all of our liberty. It protects all of us because there might be someone who is innocent, and if the government is able to just do whatever it wants in criminal process, we are all at risk.
Well, and I think we've all seen cases where that happened. I mentioned to you yesterday that I spent nearly a decade as a prosecutor. Especially when I had serious cases, I wanted the best defense attorney possible on the other side. I wanted a case that if I won it, usually went up on appeal automatically if it carried a heavy penalty. I wanted the court, the appellate court, to look at it and say, okay, there were not errors of counsel on either side. But I also, as a strong proponent of our Constitution, I think what you're saying is something I totally agree with. We have to have the individual's rights protected. It doesn't mean the defense counsel is in favor of murder or rape or armed robbery, but the rights have to be protected. And let me tell you about another area. I've authored and I've long championed the bipartisan John Lewis Voting Rights Advancement Act. I think it would help curtail the growing wave of voter suppression sweeping across our country. Again, something we don't have to worry about in Vermont, unfortunately, do in other states. I'm passionate about this legislation. I've always believed that our democracy is stronger when we expand, not shrink, the ranks of our citizens who fully participated. I believe our democracy goes stronger with your historic nomination and your presence before us today. And I've told you privately how my family members feel about that. Why is it important for our democracy's institutions, courts and all others, to reflect the rich diversity of our nation's citizenry?
Thank you, Senator. One of the things we've been talking about is the difference between the judicial branch and the other branches of government. We have three branches in our federal system, and the legislative branch has certain powers and it can do certain things to ensure that its prerogatives are achieved. And the executive branch has the power of might. The president controls the military. The judicial branch, its force in our system is the protection of the rule of law, which can only be done by essentially the consent of the governed. It can only be done if people in our society believe, decide, and agree that they're going to follow what it is that courts decide. And so one of the reasons why having a diverse judicial branch is important is because it lends and bolsters public confidence in our system. We have a diverse society in the United States. There are people from all over who come to this great nation and make their lives. And when people see that the judicial branch is comprised of a variety of people who have taken the oath to protect the Constitution and who are doing their best to interpret the laws consistent with that oath, it lends confidence that the rulings that the court is handing down are fair and just, that everything has been considered, that no one is being excluded because of a characteristic like race or gender or anything else. And that's important. I would also say that that it's important from the standpoint of role modeling, that I have been so touched by the numbers of people who've reached out to me in this period of time to say how much it has meant to their daughters, to their sons, to the next generation, that I've been appointed, to nominated and hopefully confirmed.
Well, I agree with you. I've certainly seen that within my own family. You know, we do have areas where we agree on things on this committee. Senators Grassley and Senator Cornyn, myself and others believe in transparency as part of our democracy. We've done this with the Freedom of Information Act, where we've updated number of years, Senator Cornyn and I have been the key sponsors of legislation joined by Senator Grassley, Senator Durbin, and others to improve the Freedom of Information Act. You've talked about the detailed opinions you've written to try to do the same thing. I think it's safe to say you believe transparency is central to the duties of a judge. Do you intend to carry that attitude and you will become a member of the U.S. Supreme Court?
Thank you, Senator. The value of public confidence, which I was just discussing, I think is enhanced when the public understands the reasons that a judge renders his or her ruling. One of my mentors used to say, people think the judicial branch is so secretive, but in fact, the judicial branch is the only branch that actually has to tell everyone, that actually has to write their opinions and explain why it is that they did what they did. And so I've tried in the nearly 10 years that I've been on the bench to make my rulings transparent, to explain all of the inputs that I have considered with respect to the case, to lay out the law as I see it in interpreting what Congress, for example, has done in with respect to a particular case, and what legal provisions that I think are relevant to the dispute, and then to explain my analysis. Why am I granting this motion or denying this claim? And my hope is that it will help people to be confident in my reasoning, and even if they disagree with it, they will understand what it is that I think, and I think that's important for public confidence in promoting the rule of law.
Well, you had talked about your clerking for justice prior and how it opened up doors of opportunity. I remember so well our conversation in my office, in the President Pro Tem's office, talking before these hearings began. You told me what you thought it meant to your parents and your family, your husband, your daughters, your parents who have been here throughout this, and what it would have meant to your grandparents. You said you were the lucky first inheritor of Dr. King's civil rights legacy. I keep a daily journal. I wrote that down. It means a lot. So let me do this sort of an open-ended question. You patiently answered our questions this week. I told you the reaction in Vermont was disappointment in some that were obviously political. I heard that from both Republicans and Democrats because they think it should be your legal thoughts in the Supreme Court. So I'd like to give you an opportunity to speak directly to the American people, including our little state of Vermont. Is there anything you want to convey to them about what kind of Supreme Court justice you would be if and when you're confirmed? It's all yours, Your Honor.
Thank you, Senator. Well, first, let me just address my comments to you in your office, which is something that I've said in speeches because it speaks to who I am and what I value. My parents grew up in Florida under lawful segregation. And what that means is that when they were coming through middle school and high school, they were not allowed to go to school with white students. This is in the era before and right after the Brown versus the Board decision. There was lawful segregation in places in this country. And it was after that time that Dr. King made his famous comments that people mention about having a dream where people can be judged by not by the color of their skin, but by the content of their character. And I then was born in 1970, and the contrast between my reality growing up in Florida and my parents' reality growing up in Florida, like night and day, in terms of the opportunities that were available to me that weren't available to Judge Motley, who is one of my role models in the law. And so, what my being here, I think, is about at some level, is about the progress that we've made in this country in a very short period of time, I would say. It seems like a long time, but one generation, we've gone from the reality of my parents' upbringing to the reality of mine. And I do consider myself, having been born in 1970, to be the first generation to benefit from the civil rights movement, from the legacy of all of the work of so many people that went into changing the laws in this country so that people like me could have an opportunity to be sitting here before you today. What I would hope to bring to the Supreme Court is very similar to what 115 other justices have brought, which is their life experiences, their perspectives. And mine include being a trial judge, being an appellate judge, being a public defender, being a member of the Sentencing Commission, in addition to my being a Black woman, lucky inheritor of the civil rights dream. And in my capacity as a justice, I would do what I've done for the past decade, which is to rule from a position of neutrality, to look carefully at the facts and the circumstances of every case without any agendas, without any attempt to push the law in one direction or the other, to look only at the facts and the circumstances, interpreting the law consistent with the Constitution and precedents, and to render rulings that I believe and that I hope that people would have confidence in.
Thank you. And Chair Durbin, I've had the opportunity to be here. The first justice I got to vote on was John Paul Stevens, nominated by President Gerald Ford. Proud to vote for him. And it's a long arc, Judge Jackson, but I am so proud of your answers and I appreciate you back.
Thank you, Senator Leahy. Let's take a break for about 15 minutes.
Thank you.
Thank you very much, Judge.
that Europe has not experienced since World War II. Over these 4 weeks, we have seen a growing number of civilian casualties, including women and children, and millions of people fleeing their homes, internally displaced or seeking refuge in neighboring countries that are showing incredible and commendable solidarity. The war has extended to highly populated cities, where the use of explosive weapons is causing unbearable human suffering. We have been also witnessing the devastation of essential infrastructures, such as hospitals, schools, bridges, highways, and water systems, which will aggravate the condition of the civilian population for years to come. Notwithstanding this dramatic situation and in total disregard of the appeals repeatedly made by the Secretary General and of the resolution adopted by the General Assembly on March 2nd, the Russian aggression continues to unfold, further challenging the basic principles of international humanitarian law. At the same time, the Security Council continues to be unable to address the situation in Ukraine, including its huge humanitarian consequences due to the behavior of one of its permanent members, which happens to be the initiator and the sole responsible of this war. This is the reason why a cross-regional group of member states, including Italy, requested the resumption of this emergency special session. If the Security Council cannot act on such a fundamental question, the General Assembly has the right and the obligation to retake the initiative. To protect the civilian population in Ukraine, it is essential that Russia immediately stops this aggression, guarantees the safe passage of civilians, the unimpeded access to humanitarian assistance, and urgently and genuinely engages in negotiations for peaceful resolution. These are the main contents of the draft resolution that a cross-regional group of member states has submitted to this meeting of the emergency special session, and that already enjoys the support of a high number of co-sponsoring states. We trust that in face of this unbearable humanitarian tragedy occurring in the heart of Europe, the General Assembly will respond, as it did on the 2nd of March, with a great display of cohesion, sense of responsibility and determination. And it should also be kept in mind that this war of aggression is seriously affecting food security in different parts of the world. This is the time to act without hesitation, reaffirming the imperative and erga omnes character of international humanitarian law, while maintaining at the same time a clear and unequivocal distinction between the aggressor and the victim. Let me conclude, Mr. President, my intervention by reaffirming our full solidarity with the millions of people suffering from this war of aggression. Together with European partners and allies, Italy will continue to do its part in providing humanitarian assistance and will continue to stand with Ukraine and its people. I thank you.
I thank the distinguished representative of Italy. I now give the floor to the distinguished representative of Brazil.
Mr. President, as the conflict in Ukraine lingers on, the dire humanitarian situation in the region is further deteriorating. Brazil is deeply concerned with the growing reports of civilian casualties, including children, as well as the increasing flows of refugees and internally displaced people. Joining the efforts to alleviate the refugee crisis in Europe, Brazil quickly implemented a humanitarian visa policy for people fleeing the conflict in Ukraine. For the past weeks, our embassies in the regions have been granting special visas for Ukrainians and stateless persons, many of whom have already arrived in Brazil. Moreover, in response to the most pressing needs for humanitarian assistance, the Brazilian government has sent last week a donation encompassing water purifiers around 9 tons of food and half a ton of medical items, totaling approximately 2,000 items. With the assistance of the Embassy of Brazil in Warsaw, the supplies were landed at that capital and delivered to Ukraine in coordination with the country's authorities. The international community must come to the assistance of the people most in need, not only those directly afflicted by the hostilities in Ukraine territory, but also the refugees in neighboring countries. Mr. President, there is no question about the immense human suffering and devastation caused by armed conflicts. Hence, cessation of hostilities is still the best way to minimize their humanitarian consequences. The conflict in Ukraine may also have a devastating impact on food security, disrupting food systems and increasing the risk of hunger for the entire world, particularly for developing countries. Once again, Brazil reiterates its call for the immediate cessation of hostilities in Ukraine. Brazil is also concerned about the indiscriminate imposition of broad economic sanctions, whose negative impacts will affect all countries, putting additional hardship to already strained economies recovering from the pandemics. In the end, the most vulnerable will suffer the consequences of measures proved to be mostly ineffective. Mr. President, while the conflict is still ongoing, all parties must fully abide by international humanitarian law. Parties must always uphold the principles of distinction, proportionality, precaution, and humanity. Brazil encourages increased dialogue between Ukraine and Russia to agree on clear and concrete parameters to implement their obligations under international humanitarian law as a means to increase the safety of civilians and of humanitarian personnel. Civilians wishing to flee the hostilities must be able to do so in safety, and those who decide to stay cannot become targets of attacks. In the same vein, parties must grant safe passage to relief consignments to those in need. Brazil is deeply concerned with the impact of the conflict on the most vulnerable, including on reports about difficulties to evacuate people with disabilities. International humanitarian law aims to safeguard human dignity even in the worst scenarios of conflict. They are the bare minimum that should unite rather than divide us. The reasoning behind it is clear. No matter the causes of a conflict, once it erupts, civilians must be spared, the wounded must receive medical care, humanitarian assistance must reach those in need, and detainees must be treated humanely in all circumstances. The rules of war are not optional. When the lines between combatants and civilians become blurred, we risk seeing a rise in civilian casualties, especially in armed conflicts fought in urban areas and when explosive weapons are used in these contexts. Civilians are being called to join the fighting, possibly with no proper training. Parties should strive to ensure the protection of civilians and of critical civilian infrastructure, no matter where hostilities are conducted. The reports of attacks on healthcare facilities in Ukraine, resulting in dozens of deaths and injuries, are particularly worrisome. Health workers and medical facilities have special protection and should not become military targets. Mr. President, the General Assembly has once again been convened to address a pressing situation of a threat to international peace and security with dire humanitarian consequences. The United Nations must act responsibly and in a meaningful way. We should strive to act together towards measures that will have a meaningful impact on the ground and that can lead to a lasting peace in Ukraine. I thank you.
I thank the distinguished representative of Brazil. I now give the floor to the distinguished representative of Indonesia.
Thank you, Mr. President. After our last meeting earlier this month, it is disheartening that today we again have to meet to address the deteriorating humanitarian situation in Ukraine. As we speak, millions of innocent civilians are caught in the crossfire, trapped between bleak options of having to leave their home or trying to survive in increasingly dangerous and dire conditions. Many civilians have already had to pay the ultimate price. In many parts of the country, basic public services are no longer available. Key infrastructures are being destroyed at an alarming pace. It will take years and tremendous amount of resources to rebuild. Mr. President, the world is looking to the UN to take action, to help alleviate the suffering of the innocents, to save lives. We have the responsibility to send a clear and united message to all parties. First, they must spare no efforts to stop the war. They must take immediate steps to de-escalate, stop the hostilities, and establish a sustainable ceasefire. Second, international humanitarian law must be respected, including its provision regarding protection of civilians and civilian infrastructures. Humanitarian assistance must be given access to all people in need in all areas without exceptions. Safe passage must be guaranteed. Civilians wishing to leave and evacuate from Ukraine must be facilitated. Third, dialogue and negotiation must be intensified. Lasting peace will only come from the negotiating table. We have to collectively push for dialogue and peaceful solution. Anything short of this objective will only worsen the humanitarian crisis in Ukraine. Mr. President, many have pointed out that the situation in Ukraine is on a scale that is not seen in Europe for decades. Its humanitarian ramification has been devastating. While war in its nature is divisive, the question for us today, can we be united in this august body to address the humanitarian crisis in Ukraine? Or will we allow ourselves to be divided and let our differences take the better of us and stand idle while many are suffering? For Indonesia, the answer is crystal clear. We want the General Assembly to maintain its unity and take a united action to help address the humanitarian crisis in Ukraine. After all, the UN is the global body that has the comparative advantage to address humanitarian crisis. Anything less will only further reduce global trust and respectability of the United Nations. It is time to put humanity beyond and above political differences and work towards the ultimate goal to end the war and the suffering and to achieve perpetual peace in Ukraine. I thank you.
I thank the distinguished representative of Indonesia. I now give the floor to the distinguished representative of Thailand.
Mr. President, Thailand is gravely concerned by the ongoing humanitarian crisis in Ukraine and is deeply saddened by the loss of innocent lives and destruction of property and civilian infrastructure in Ukraine, as well as by the plight of affected civilians, including those who have fled neighboring countries. We call for the respect for and the protection of civilian life and infrastructure, and for the facilitation of access to humanitarian assistance to those affected within and around Ukraine, without discrimination on any basis, and without politicization. In this regard, Thailand calls on all parties to fully comply with their obligations under international humanitarian law and international human rights law, and underscores the need for all actors engaged in the provision of humanitarian assistance to promote and fully respect the principles of humanity, neutrality, impartiality, and independence. Thailand reaffirms our commitment to support the international community to alleviate the consequences of ongoing humanitarian crisis in Ukraine, which has already been challenging due to the impacts of the COVID-19 pandemic. On our part, Thailand has provided humanitarian assistance, including food, medical, and other essential supplies to the affected civilians through the Ukrainian Red Cross Society. Additionally, the Thai Red Cross Society has also provided financial contribution to the Ukrainian Red Cross Society in support of the ongoing humanitarian operations, as well as raising funds from the public for the Ukrainian Red Cross Society's relief activities. Mr. President, the escalation of the situation will only cause wider impacts, including humanitarian consequences in Ukraine and around the world. Thailand therefore welcomes and encourages continued efforts at bilateral talks between the concerned parties, looks forward to their fruitful outcomes, especially to help ameliorate the pressing humanitarian situation, and hopes for the peaceful settlement of the situation. I thank you very much, Mr. President.
I thank the distinguished representative of Thailand. I now give the floor to the distinguished representative of the Dominican Republic.
Muchas gracias.
Many thanks indeed, Mr. President. We are meeting here today, member states of the United Nations. Microphone for the speaker, please.
Contra Ucrania. Atrapadas en este.
Trapped in this conflict are millions of people, men, women, children, older persons, persons living with a disability. These groups are those that pay the highest price in this deeply regrettable situation. They pay with their suffering, with their lives, their future, and their psychological well-being. They're paying for our inability to spare them this suffering, and they're paying for our inability to prevent the fracture of their lives and dignity. The Dominican Republic feels entirely confounded by the fact that today we have 2 draft resolutions on the table. In spite of our indignation, today we will take a decision based on principles and keeping our focus on the millions of civilians that need protection by the parties to the conflict. With this in mind, allow me to make the following observations. First, it is vital that we see observed without delay and without conditions all the rules governing the conduct of hostilities contained in international humanitarian law. It is vital that we move towards the search for a negotiated solution which will restore peace in Ukraine. And when a cessation in hostilities is not viable, all necessary measures must be taken to avoid human suffering. These include and must include humanitarian access to affected civilians and must include the refraining from attacking civilian infrastructure such as hospitals, schools, and electric and water infrastructure. Mr. President, any and all people trapped in an armed conflict are vulnerable and suffer. However, there are those that are more vulnerable than others. Women, children, older persons, and internally displaced persons are particularly at risk. However, those living with a type of disability deserve and require our immediate attention. Cooperation between all actors on the ground is vital so that we can protect these people. We must do so by facilitating their movement or evacuation to safe places, and we must guarantee that their medical and care needs are met. To conclude, Mr. President, it is with deep sorrow that we affirm that if this conflict continues, its humanitarian consequences will extend beyond Ukraine's borders. Both the Russian Federation and Ukraine produce around 25% of the world's wheat and grain supply. Many countries depend on this supply, and the impact of the conflict on food security of citizens could quite simply be devastating. Let us not allow this to happen. Let us not increase this suffering. On the contrary, let us not allow the situation to continue escalating. Let us not allow this conflict to be responsible for millions of people who already suffer food security descending into the abyss of a famine. Many thanks, Mr. President.
I thank the distinguished representative of the Dominican Republic. I now give the floor to the distinguished representative of Albania.
Mr. President, 24 February, 23 March, already a month into the Russian aggression in Ukraine, and the devastating situation needs no description. Figures are staggering. 12 million people are stranded in affected areas, directly exposed to insecurity, and many of them completely cut off from basic supplies, including food, water, and medicine. This represents more than 25% of the entire population of Ukraine. 10 million people have been displaced from their homes. Over 3.5 million, otherwise 100,000 per day, have fled the country, 90% of them women and children. 2,500 civilian casualties, knowing that in conflicts such figures are much higher. Massive and indiscriminate bombing campaigns have reduced entire cities to ruins. Residential areas, homes, schools, hospitals, theaters, commercial areas, everything is a target. Mariupol, the new Aleppo, has become the true face of Russia, a permanent member of the Security Council that has awarded itself a license to kill civilians and destroy cities. Dear colleagues, we know that Moscow's initial blitzkrieg plans have been derailed by the Ukrainian resistance. Ukrainians, with their resolve and conviction, know what they are fighting for. Russian soldiers, in their disbelief, do not know what they are dying for. Let's not forget, this is not a war of Russians against Ukrainians. This is a war of one man in his own seclusion, and who, by his reckless actions, has managed to generate in a few weeks the biggest ever solitude and world isolation for his own country. History has seen more than once failed efforts by strong men to rewrite history, but with their crimes only ending up being their epitaph. Dear colleagues, this war, fueled by hubris, narcissism, and paranoia, is systematically, methodically, and cold-bloodedly devastating Ukraine. The massive refugee crisis is a serious and profound challenge to Europe. But this cynical blackmail is doomed to fail, just as the one on West Berlin failed in 1948. Yet this crisis is affecting the entire world, especially the developing countries. The very sharp rise of prices of basic commodities because of the war is making the poor poorer, the vulnerable more vulnerable. No one can call this an unintended consequence because it was known. This is what Russia is further inflicting to Ukraine and to the world. Dear colleagues, Albania has co-sponsored this draft resolution on aggression against Ukraine. We wish it could be implemented to help protect civilians, but we doubt, if approved, and I hope we will, that it will be respected by Russia. It is hard to believe that a country that has blatantly broken every rule in the book of international law will fall for the text which it has undermined in the Council and is trying to undermine here. This is why we need to show again what we stand for, support a text that spells clearly why we have this situation, what needs to be done, and by whom. A text that has only one definition for aggression: aggression. Dear colleagues, we know that no future can ever be successfully built while living in the past. Therefore, make no mistake. If Russia succeeds in this illegal war, we all have been warned. The line will not be drawn at Ukraine. I thank you.
I thank the distinguished representative of Albania. I now give the floor to the distinguished representative of Poland.
Mr. President, distinguished delegates, Poland fully supports the text of the resolution submitted by Ukraine on the humanitarian consequences of the aggression against Ukraine. We align with the statement delivered by the European Union and would like to complement it with our national perspective. Humanitarian situation in Ukraine is deteriorating at an alarming scale. UN OCHA estimates that 12 million people are expected to be in need of humanitarian assistance, which means that almost 30% of the entire population of the country will require aid. People trapped in Ukrainian cities are in need of urgent humanitarian assistance. The sole actor responsible for this disaster is Russia. Distinguished delegates, 1 week ago, Russian forces dropped a bomb on a theater, clearly marked as a civilian object sheltering children, where hundreds of civilians were seeking safety in the besieged city of Mariupol. This is a clear manifestation that Russia deliberately creates humanitarian catastrophe in Ukraine and blatantly disregards the principles of international humanitarian law. Within the last days, we are witnessing brutal and inhumane tactics of the Russian army aimed at terrorizing the civilian population by indiscriminate attacks on civilians and civilian infrastructure, depriving them even of access to potable water and electricity. Poland condemns in the strongest terms attacks against civilians and civilian objects, such as schools, hospitals, orphanages, and critical civilian infrastructure. These acts constitute grave breaches of the Geneva Convention, of which 196 countries, including Russia, are parties, as well as serious violation of laws and customs applicable in an international armed conflict. These acts are war crimes under international law. We must not remain silent. By voting in favor of the draft resolution presented by Ukraine, we voice support for immediate cessation of hostilities and ensuring humanitarian access. That is what we, as the international community, are obliged to deliver. Since the beginning of Russian invasion, the OHCHR has reported almost 2,500 civilian casualties in Ukraine, including 925 persons killed. Real numbers are likely much higher. It must stop. By voting in favor of the draft resolution presented by Ukraine, we voice support for immediate cessation of hostilities and ensuring humanitarian access. This is what people in Ukraine desperately need. This is what we, as the international community, are obliged to deliver. Distinguished delegates, the humanitarian consequences of the ongoing war brought by Russia on Ukraine are not limited to Ukrainians in their home country. As a neighbor and close friend of Ukraine, we in Poland see firsthand the dramatic humanitarian consequences of the Russian aggression against Ukraine. Every day, at the Polish-Ukrainian border, we witness constant inflow of people who enter Poland, severely traumatized. Since 24th of February, already more than 2.5 million were forced to leave Ukraine as a result of Russia's military aggression, out of which 2.2 million fled to Poland, and most of them found shelter and stayed there. In the spirit of solidarity, Poland will continue to admit and provide shelter, food, healthcare and safety to every person in need, regardless of their nationality, race or religious creed. We have registered already 170 nationalities on our border. The consequences of Russia's invasion on Ukraine are being felt in almost every country around the globe. It affects Ukraine, it affects Europe, it affects us all. Distinguished delegates, the resolution submitted by Ukraine focuses on urgent humanitarian needs and expresses support for the efforts of the United Nations and humanitarian organizations to provide help to the Ukrainian people, and further demands a cessation of hostilities and urges humanitarian access. It also reflects on the broader consequences of the war, including the food security worldwide, in particular in least developed countries. Moreover, it contains strong language on the need for the protection of all civilians fleeing the war without discrimination, including foreign nationals, notably students. We call on each member state to stand firmly behind the resolution on the humanitarian consequences of the aggression against Ukraine and vote in favor. This is the text that was elaborated together with and agreed upon by Ukraine, thus respectful of the particular needs of the country most concerned. As a member of the cross-regional group of countries who worked on this resolution, Poland would like to emphasize that we have ensured an inclusive and transparent process. We are convinced that by supporting this resolution, we demonstrate our support to the people of Ukraine who are facing dramatic humanitarian consequences of the war brought on them by Russia. 76 years ago, this assembly decided that we are determined to save succeeding generations from the scourge of war. At the moment, we are failing. Every day, more people are being killed, including children. Hundreds of thousands remain trapped in besieged cities, very often without access to water supply and medicine, with food supplies close to running out. It is our obligation to act now by voting in favor of the resolution presented by Ukraine. And thank you.
I thank the distinguished representative of Poland. I now give the floor to the distinguished representative of Chile.
Señor Presidente,
Mr. President, Chile reiterates once again its total condemnation of the Russian Federation's invasion of Ukraine. Since the historic special session of this General Assembly, which began on the 28th of February, the situation on the ground has worsened dramatically, and we're seeing even the use of new missiles with staggering destructive capacity. Moreover, we've seen an increase in the bombing of hospitals, schools, and residential neighborhoods in which civilians could still be found. Mr. President, Chile supports and has co-sponsored the resolution entitled Humanitarian Consequences of the Aggression against Ukraine. This resolution focuses on the devastating humanitarian consequences that we're witnessing. We're co-sponsoring this resolution because that is what we're being asked to do by the civilian victims of the cruel land and air attacks waged by the Russian Federation. International law and international humanitarian law and the human rights doctrine signal to us the instruments to be used in cases such as that we're witnessing in Ukraine. The resolution submitted to a vote indicates which instruments would be appropriate for use in situations such as these. These include, inter alia, the cessation of any attack against a civilian population, the most robust protection possible for civilians, including humanitarian personnel, journalists, and persons in vulnerable situations, including women, girls, and boys, and the protection as well of medical material and personnel, their means of transport, and of hospitals. Moreover, such instruments include guaranteeing the security, dignity, human rights, and fundamental freedoms without any type of discrimination, both on Ukrainian territory and the territory of those countries in which refuge is being sought, of all persons fleeing the conflict and the violence, regardless of their status. Measures also include the total condemnation of any and all act, manifestation, or expression of racism, racial discrimination, xenophobia, and forms of intolerance against persons on the move, including refugees. We must also ensure security guarantees for humanitarian corridors. Mr. President, today, as an international community, as human beings, we have the responsibility to protect the civilian population and to protect the civilian population affected by this conflict, which is the fruit of an act of aggression, and we must guarantee humanitarian aid for them. Consequently, we thank all member states that are today hosting the more than 4 million people that have been forced to abandon Ukraine as a result of this conflict. Before concluding, my country wishes to reiterate its appeal to all parties to continue conversations. Once again, we urge the peaceful and immediate resolution of the conflict between the Russian Federation and Ukraine. This solution must be found through political dialogue, negotiations, mediations, and other peaceful means in accordance with international law. Many thanks, Mr. President.
I thank the distinguished representative of Chile. I now give the floor to the distinguished representative of Liechtenstein.
Thank you very much, Mr. President. We welcome the reconvening of the emergency special session on the situation in Ukraine. 3 weeks ago, this assembly issued a clear call with respect to the aggression against Ukraine by an overwhelming majority. It asked for the immediate cessation of hostilities, as well as the complete and immediate withdrawal of all troops from Ukraine, with a view to creating the necessary space for genuine diplomacy, as well as a credible and fully inclusive peace process. The reaction of the Russian Federation shows a complete disregard for the multilateralism embodied in the decision of this assembly and of the order of the International Court of Justice of March 16th. Not only has it failed to heed the unequivocal call from this assembly, it has engaged in further military escalation. Mr. President, in Ukraine, we see in the starkest possible terms the axiom that whenever war begins, war crimes follow. The aggression committed against Ukraine must therefore remain front and center in our discussions as we address its consequences, as well as the individual criminal responsibility it entails for persons in leadership positions. Incalculable suffering has been visited on Ukraine since this assembly last met. It is not only that the civilian population has borne the brunt of its impact, civilians have increasingly been targeted by the Russian armed forces in blatant violation of the most fundamental principles of international humanitarian law: military necessity, distinction, and proportionality. A large part of the civilian population has been forcibly displaced as a result. The onslaught on Mariupol is particularly appalling and eerily reminiscent of the notorious assault on Aleppo in its indiscriminate attack on civilian infrastructure and the infliction of mass civilian casualties as a method of warfare. Mr. President, all of this extends far beyond the discussions we are engaged in today. It is a frontal rejection of multilateralism that this assembly embodies, and that is so urgently needed to address other challenges of our time, from fighting climate change to overcoming the devastating impact of the COVID-19 pandemic and the inequalities exacerbated by it, to addressing humanitarian and other emergencies in all parts of the world. The people of Ukraine are the primary victims of this war, but its impact is already felt around the globe. The attack on a major agricultural producer will be devastating for global food security. The forthcoming growth in military expenditure will make for a more dangerous world. there will be massive fallout on agendas that were already in a fragile state before the aggression against Ukraine, from the abolition of nuclear weapons to achieving the SDGs. All of this cannot be undone in its entirety, but the effects can be mitigated by one measure, an immediate end of the invasion as this assembly has requested. Mr. President, in response to the aggression, there has been an unprecedented way in which governments and private sectors have come together to stand up for the fundamentals of the post-World War II order. This is a positive takeaway if we can apply it to other challenges in the future. The resolution this assembly passed on March the 2nd has resonated in a powerful manner around the globe. This assembly has proven its ability to act decisively when the Charter is under threat. The present crisis can be a defining moment for this assembly and its ability to show leadership that will be required with respect to other challenges. Mr. President, this organization has extensive experience in the area of humanitarian assistance, including in the most difficult of circumstances. This assembly and other relevant UN bodies have set the ground rules for the delivery of humanitarian assistance. The relevant rules defined in international humanitarian law are universally accepted. Nevertheless, we are called upon today to ask for these rules to be respected. Among other things, the granting of safe passage in both directions for those fleeing and for those delivering humanitarian aid, the protection of civilians at all times and under all circumstances, the prohibition of the attack on critical civilian infrastructure at all times, and the absolute prohibition of illegal weaponry. Mr. President, we support the effort reflected in the resolution before us to uphold core humanitarian objectives in the context of its call upon the Russian Federation to cease hostilities against Ukraine. We have therefore co-sponsored resolution L2 before this assembly and hope that this assembly will vote with an overwhelming majority in support of it. I thank you.
I thank the distinguished representative of Liechtenstein. I now give the floor to the distinguished representative of Slovenia.
Thank you, Mr. President. Slovenia aligns itself with the statement delivered by the European Union, and I would like to make the following.
All right, ladies and gentlemen, we are still live here. This is the Stock Market Live with LCAOD. It's really a chill day today, as you can see. I'm just being real observant here, watching all these briefings. Trying to see what's moving the market. It looks like this emergency briefing is moving the market here a little bit. They're talking about the Russia-Ukraine situation. This is the United Nations General Assembly, 11th emergency special here. So this is really rising the markets right here. Amazon's on the high. Tesla's picking up here. Everything is picking up here. Microsoft is picking up. So yeah, be cautious, you guys, what's going on here. Looks like Euro close was about 30 minutes ago. We're seeing the effect here now. Looks like the U.S. brought it up. It's 12:03 p.m. Wall Street lunch break is approaching, ladies and gentlemen. LCLD lunch break is approaching, so we're going to continue to watch this United Nations briefing here. It's moving the market. It's live. Let's tune back in, you guys. Market is picking up, though. Market is picking up. I repeat, the market is picking up. The SPY is on the high right now. 448.49 just tagged it. Looks like we want to retest 450 today. It's going to be a fight, a battle, though. But if we can get there, the stocks will go higher. The bull market is officially begun here. It's begun about 4 days ago, but it confirmed the bull market this morning with the continuation here this morning. So even though it's a red day, excuse me, even it being red right now, the market like the Dow and the S&P 500, the Nasdaq flipped here. It's green, leading the way up 28%. The Russell 2000 is still down. So we got a mixed market here. Everything's red except the Nasdaq. The Nasdaq is the only thing green, causing the stocks to hold their gains right now, you guys. So stay cautious about that. Amazon's over 33.20. Looks like we're going to really get that 33.50 by Friday. It's approaching, and we're trying to get Tesla above 1,040 by Friday, and then they'll rally to like 1,080 if so. So keep that in mind here. 33.50 is the high on Amazon for the end of the week. We're trying to reach, and 1,080 is the high on Tesla. We're trying to reach by the end of the week here. But right now we got to break resistance at 10.40 on Tesla and 33.20 on Amazon. So let's see if it breaks here or this is top. That's what we're seeing right now. Let's tune back into this briefing here. And we will be taking lunch here on time today in about 30 minutes. So keep that in mind, ladies and gentlemen. This is the Stock Market Live with LCAOD.
Without any discrimination. Resolution accurately reflects the situation on the ground and calls for the respect of the UN Charter and the international humanitarian law to be respected. We stand ready to assist further. We stand with Ukraine. I thank you. I thank the distinguished representative of Slovenia. I now give the floor to the distinguished representative of Ecuador.
Mr. President, excuse me, says the Speaker. Diego is the name of the Ecuadorian student of 20 years of age that arrived in Ecuador yesterday, fleeing the shelling, the explosions, and the tragedy sparked by the military aggression against Ukraine. Diego took shelter in a bunker and learned to live from day to day in the midst of a conflict which was alien to him. He's also a living witness of the fact that the special military operation is nothing other than a clear invasion of Ukraine, of its people, and an act of aggression against the United Nations Charter. Around 700 Ecuadorians, including Diego, were successfully evacuated by my government in 3 humanitarian flights since the beginning of the war, which has plunged humankind into mourning in which it has stayed for a month now. The Ukrainian friend of Diego was not as lucky. He was not able to cross the border. And every one of these 700 Ecuadorians that we've been able to evacuate knows a family, a mother, a father, a son, a daughter that continues to live with the spectre of destruction and death hanging over them. And despite the fact that my compatriots that are today safe and sound will never forget the ordeal they went through, they're also all acutely aware that their suffering and pain in no way compares to the suffering and pain that the military aggression is inflicting upon the people of Ukraine. In honor of all of the evacuated foreign students and in honor of those who stay, as well as in honor of all of the Ukrainian people, and in particular in order to equip the international community with one more tool, Ecuador joined the key proponents of draft resolution L2, whose 6th operative paragraph reads, and I quote, "The Assembly demands that all parties protect civilians fleeing armed conflict and violence, including foreign nationals, notably students, without discrimination, to allow voluntary safe and unhindered passage, end quote. The statement that I made exactly 1 month ago before this General Assembly calling parties to dialogue, de-escalation and a diplomatic solution was pulverized only a few hours later when the first bombs fell. How many times did we hear in the Security Council and in statements made to the media that there wouldn't be an invasion? The denial that military attacks would be waged, to a certain extent, limited the possibilities for safe evacuation, and consequently, we saw the exacerbation of the impact on the civilian population, and this impact is growing ever graver, day by day, minute by minute. Today, I'm attending this meeting because Ecuador believes that all is not lost. We still can and we must achieve an immediate cessation of hostilities, just as is called for by the resolution in its second operative paragraph. Indeed, this is also what's called for by common sense and our ethic responsibility as human beings. This morning, the permanent representative of Japan clearly stated that the grave humanitarian situation in Ukraine would continue if we do not tackle the root causes and grapple with the essence of what's happening. The draft resolution of an interregional group that Ecuador is co-sponsoring does just that. It tackles the causes and consequences of this devastating humanitarian crisis. For these reasons, and in light of all of the above, Ecuador will vote in favor of the draft contained in document A/ES11/L2, which already is co-sponsored by at least 83 delegations. It calls upon, and we call upon rather, all delegations to do the same. I also invite delegations to remain united before the international community and to honor the role and authority of this assembly in light of the efforts to revitalize the General Assembly, which year upon year see us call for the non-duplication of work in resolutions presented. Thank you.
I thank the distinguished representative of Ecuador. I now give the floor to the distinguished representative of Costa Rica.
Señor Presidente. Mr. President, as we speak, the streets of Ukrainian cities are being used as a battlefield. Homes, hospitals, schools, community centers, and even nuclear power plants have become military targets. Millions of Ukrainians have left their homes to head towards neighboring countries, while at the same time, many remain trapped and are desperate for safe passage. They have no food, no water, no heating, no electricity. But they have hope. We are their hope. The Russian invasion of Ukraine is devastating for Ukrainian civilians, and the longer the aggression lasts, the deeper its repercussions will be in Ukraine and beyond Ukraine's borders. Consequently, as an international community, we must reiterate our appeals to the Russian Federation to cease its hostilities against Ukraine. The resolution that we will adopt offers a welcome approach to the required civilian protection in the devastating invasion of Ukraine. It underscores the need to protect those who have been forcibly displaced. It underscores the need to protect non-combatants, including journalists and humanitarian workers, among others. Costa Rica supports all provisions relating to the protection of the civilian population and civilian infrastructure.
All right, we're gonna tune back in with Supreme Court confirmation hearing. Judge Brown Jackson. Looks like they started. They took a quick break and they're live again. They started their live back about 30 minutes ago. So we're gonna tune into that. What we was just watching was the General Assembly the United Nations General Assembly, they were just holding an emergency session here about the Russia-Ukraine situation, just kind of trying to let everybody know that is still taking place, so be mindful and respectful.
Is that this defendant was so bold in his robberies. He came in April with a gun. He held the employees hostage, essentially, forcing them to open the safe with the drugs in it at gunpoint, stole the drugs. Not masked, not hiding his identity. And this is pre-COVID, so we're not talking about having to have a mask. He was a robber, plain and simple, with no fear of people identifying him. And then, in the period between April and September, he would come back to the pharmacy. He would loiter outside on the street. This is according to the victims. They would see him looking in the window. Once or twice he came inside, looking like he was going to buy something and staring them down. And they knew who he was, and they called the police, and they weren't able to, apprehend him because he hadn't really done anything at that point. And the people who worked in the pharmacy were terrified, and they were terrified by that behavior, the menacing nature of it. By the time we get to September, he actually comes in, and they think maybe this is another time when he's just loitering, but no, he pulls out a gun, he hops over the counter, he assaults one of the people who are working there and steals the drugs again. And that time they were able to call the police in enough time for them to come and apprehend him. So at his trial, he did not try. He didn't go to trial.
You're the judge?
I'm the judge. He pled guilty to this behavior, which was well documented. There was no defense that it wasn't him. But the guidelines in the case and the statutes that applied said because he used the gun, he was supposed to get something like 7 years. And I used the victim's statements to, first of all, explain to him how he had terrorized the people. Their statements said, one woman said, I can't work at the pharmacy anymore because I am so fearful that this guy will come back. It's changed my whole life. It was a whole set of really horrible circumstances that I read to him at his sentencing so that he could understand what he'd actually done. And then I sentenced him above the requirement of the law because I thought it was warranted to make clear to him that this was a terrible, terrible thing that he had done to these people. So the victim's statements were really important because they explained to me and to him the consequences of his behavior, but beyond just how many drugs he stole or the fact that he used a gun. They were the real life circumstances that resulted from his behavior, and it was important for him to understand that.
I've listened to most all of this testimony, which I think now you've gone on for over 15 hours. And I just want to say that I think you have a stamina and a very good brain and a real sense of empathy has been communicated to me in these 15 hours. And I want you to know that. One of the things that I'm concerned about is that the public perception of the Supreme Court has turned increasingly negative over the last few years. A recent Pew Research survey found that 44% of adults have an unfavorable view of the Supreme Court. Less than 3 years ago, that number was 30% of adults that held that view. And I understand that as a judge on the DC bench, you have frequently accepted invitations to speak at public events in the hopes of giving the public more information about the judicial process and more confidence in the outcome. So here's the question. Why do you think there's been a decline in the public's perception of the court? And if you are confirmed, how would you strive to improve the public's confidence in the court and its decisions?
Thank you, Senator. I think that public confidence in the court is very important. It is it's crucial to the rule of law that the public believe in the judicial process, and therefore choose to accept the rulings of the courts, not just the Supreme Court, but all of the courts. It's part of the way our process works. And I think that I have taken that to mean, in terms of my role as a judge, that outreach to the public to explain what it is that we do, to inspire, hopefully, law school students and high school students, young lawyers in law firms and elsewhere, to think about careers in the judicial branch or think about careers in law, as one of the ways that I have attempted to try to shore up public confidence. And if I'm confirmed, I would plan to continue as best as I can to do that kind of thing, because, as you say, it's very important for the public to understand the work of the court and to follow its pronouncements concerning the law.
Earlier, when you and I spoke in my office, we discussed some of the people who have mentored you throughout your career. And one of those was Judge Patty Saris. You served as a law clerk for her on the Massachusetts District Court, I believe, early in your career. And you've spoken publicly about the role she has played as a mentor in your legal career. You have described her as, quote, a consensus builder, a good listener, a careful speaker, the essence of judicial temperament, end quote. So would you share with all of the members here more about how Judge Saris's approach to judging and her mentorship have shaped you and your career? If you give some of the specifics,
Yes.
I think everybody would be interested.
Thank you, Senator. As I reflect on her mentorship and also the mentorship of my other two judges, it's very interesting because I think I learned maybe different things from each of them. Judge Saris, who was my first clerkship, you're correct. She's serves on the District Court of Massachusetts, which is the trial level court. I learned how to look at the facts in a case from Judge Saris. That's part of what the trial court level does. We, as trial judges, develop the record in a case, take testimony, have trials, and she is extraordinary at developing a record and making sure that all of the relevant facts are adduced from the witnesses and considered in the context of her trial and record responsibilities. And so that, I think, is something that I learned from her in terms of the law, and her warmth and care for her law clerks meant that she has been a lifelong mentor to me. And ironically, she became the chair of the Sentencing Commission after I had been on the Sentencing Commission. So we worked together later in my career. So I often use that story to tell young people, you never know what's going to happen. Someone who you worked for at some point might be your colleague down the line.
Well, let me just one more. You've handled a large number of cases during your career, both as an advocate and a judge. As an advocate, you've worked on a very wide variety of cases, from work for corporate clients during your time in private practice to your work for low-income clients during your service as a federal public defender. And during your 9 years as a federal judge, you've written nearly 600 opinions. I think that's really quite a sterling record. And I imagine that some of the cases have really stuck with you. And so I would like you, if you can, to talk a little bit about some of the cases, maybe one or two, that you've had that have made a deep impression and have really enabled you to progress as you have?
Thank you, Senator. Well, as you say, I have handled a lot of cases in my time, nearly decade on the bench, and you learn something in almost every case in some respect. If you're doing your job right and you're looking into all of the issues. I think there might be, I'd mention one from sort of a few years into my service as a trial judge. I handled a case, Yakai versus Napper. And the case involved trademark infringement. And you would ordinarily think that trademark infringement charges are dry and technical. And what I learned from this case is that even areas of the law that you might think apply only to businesses impact real people at times. So this case involved a small community, a cultural community of people who believe in vegan lifestyles. They call themselves the African Hebrew Israelites, but it's not a religious community. It's a cultural community around healthy living. And they have created a restaurant and a series of restaurants here in the Washington, D.C. area with menus involving really, I'm told, terrific vegan foods. And in this community, there was a member who was the one who created the recipes and who was responsible for the restaurant. The whole community had other aspects to it. He ended up falling out with the community, and the dispute involved his actions essentially taking over the restaurant and reopening it by himself using the same name. The restaurant was called Everlasting Life, which was a important phrase for this community. And he essentially ejected the other members because he was the leaseholder, or he had signed the lease on behalf of the community. And he kicked them out for a day, and then he reopened the restaurant using the same name. And so the question was, under the Lanham Act, which is the statute for trademark violations, the question is whether there is a potential for confusion in that sort of circumstance. But ordinarily, I see Senator Coons nodding, ordinarily, when you have a trademark infringement, you're talking about two different businesses who have very similar products. And the question is, are they similar enough to cause confusion? Because the idea of the law is that people should be able to have products that are identified with them, and you shouldn't be confused. And in this case, we had a bench trial about it, but it was pretty clear. I was the fact finder as the judge. It was pretty clear that when you open the same business with the same name, using the same recipes and food, that you have created this kind of problem that is a trademark violation. But what was so interesting to me about the case, in addition to the fact that I got to be the fact finder, it was a bench trial, was that we had witnesses come in who testified about the circumstances. This was a very small community, and they all knew each other, and the testimony about what it meant to them to have one of their members ejected in this way and then have him turn on them was very, very moving in the courtroom. So even though we were talking about this kind of arcane area of the law, it was real circumstances that were happening.
Well, stop for a minute.
Yes.
I think you're a very important addition to the court. And what I'm trying to fathom out from the hearing is, what kind of judge will she be? How will we look at her in 5 or 6 years? And so what I really want to ascertain is, what kind of a judge you will be. What will be the principles you hold dear, and how will you function in this capacity? If you could just answer that one question, I've been waiting for it
Yes.
about 15 hours, so I'd appreciate it. Thank you.
Well, I would hope to be the kind of judge that I have been during this last decade. I have been the kind of judge who understands that it's my responsibility to rule neutrally, to not have any agenda when I'm looking at a case. I've been the kind of judge who understands that facts matter, facts like the ones that I was just describing, and that it's important for a judge to take into account and be able to understand the arguments of all of the different parties and participants. And I've been the kind of judge who takes my responsibility to not be a policymaker, to try to understand and ascertain the will of Congress if it's a statute, or to adhere to my own I've been saying stay in my lane, to not exert my authority beyond what the Constitution requires when I'm interpreting and applying the law. I think I've been the kind of judge who lives up to the oath in terms of being fair and impartial, ruling without fear or favor, and
All right, ladies and gentlemen, it is officially Wall Street lunch break. You can see they doing the same pattern yesterday. This hearing has been going on for 3 days. So open. 1 second. Here, don't touch nothing. Get out. Get out. Thank you. Good job. Good boy. Shut it down for me. Good job. All right, ladies and gentlemen. So, yeah, as you can see, they're pulling the same pattern here as they did kind of yesterday. The only thing different I'm seeing is the market is in the red here today, but the NASDAQ is leading the way. Keep flipping red to green. Just turned green there, up 1%. That's the only difference from yesterday to today. Yesterday was mad green, so they kind of just, it was about a dip. Today is the market's still red, moving a little slowish here. They're actually selling every rip today, but it's slowly picking right back up to the same spot. So what I'm not seeing is a fall down, a major pullback back down to the downside, or a correction to the downside. I'm not seeing the bears get the momentum that they would need. Basically, I'm seeing the bulls still. Basically, it's in their control here now. It's a bull market. It has flipped here. The reversal has flipped. If your pride or ego is too big to admit that, then that's going to cause you not to stay focused. So keep that in mind. This is a bull market right now. Things reversed literally in a week. Things have changed ever since Powell announced the rate hike, and he said his little comment, and he spoke this morning. Apparently, I don't think he said anything that important. Nobody's quoted him yet. Anyway, so we'll see if what goes on by the end of the day. If we can get some more information about what he said this morning. It wasn't nothing serious but I think he just had like something like an interview with the company or something. So I don't know. It was something personal with him. Basically, he just doing his own thing out here in the world. But man, yeah, the market is red now. Though the Nasdaq is witching here. It's turning red and green. The VIX is up in the green here, up $23, up 31%. The SPY is right in the middle here, so it can go either way here. This could be your top, ladies and gentlemen. The market is kind of getting weaker and weaker. This could be the top, signaling that. So you might want to cover there. You want to cover to the downside, that is, because it looks like the market may be short today if we keep getting rejected at these new resistance levels, ladies and gentlemen. But I don't know if we will continue to keep getting rejected at these new resistance levels. It really doesn't seem like they won't for too much longer, but as of right now, they are. So that's why I'm stating this could be the top. It could be getting weak here, but with the VIX down this low, if it get lower, you know what I'm saying, it'll easily reverse here and just poof, like spike somebody will just drop a big amount of money into the entire market, and it'll shoot up instantly. if it wants to. So keep that in mind, man. That's why I'm saying the SPY is in the middle. It can go either way. Here, the SPY is the ETF. It controls the majority of the stocks. If you didn't know, now you know. That's why I have the SPY, the Dow Triple Qs, and the Nasdaq. Sometimes, excuse me, the Nasdaq follows with the Triple Qs. I always have the SPY down, the Triple Qs and the VIX up on my screen constantly, ladies and gentlemen, because that's giving me my indication of what I need to know as far as my stocks that are going the direction that I would hope so that they go, ladies and gentlemen. So to get paid being a trader is all about direction, and to get paid with being an investor, being a shareholder, buying shares, it's just all about time. Literally about time, nothing else. You can only get paid if the stock goes up with shares. Keep that in mind. Let's keep that in mind. Keep that in mind. You know what I'm saying? So you can only get paid if the stock goes up with shares. Shares now. There's two ways you can invest. That's why I say you're either a trader or an investor, or you're both. Investors mainly focus with stock. Traders focus with options. That's called options, ladies and gentlemen. Stock and options. You can trade and invest two ways. Market's pulling back here right now. So Wall Street lunch break just kicking in. Of course, they sold. They're about to go eat food, ladies and gentlemen. I am too. I'm just giving you guys a little game here before I go to the break, because I was an hour late today, and I've just been watching these briefings. I haven't been speaking too much, but this is for the people that's replaying the recap. And who's live with me right now, ladies and gentlemen? I have a whole comment section. I have a Discord community that I work with, and I know some people locally tunes in. So I'm just spitting game with just universally right now. But the market is pulling back here right now. Like I said, it could go either way. I just told you the SPY is coming down now because it was in the middle. Now we're still in the channel. Now we're just a little below VWAP on the SPY. So the bears do have momentum, but this is not their market anymore. This is the official beginning of the bull market. Keep that in mind. But the bears got a little slight momentum right now. So it looks like another discount, another opportunity for people to go long. That's all I'm really seeing here. Like I said, look at the numbers here. Numbers and charts. It's not flushing, you guys. We're not at those numbers we were weeks and months ago. Keep that in mind. We're higher. We're back to last year. We're in that area. We have attacked it. So this is a bull market officially here. So it's a lot going on as far as the leaders here, like Amazon and Tesla. This is concerns with lawmakers. They're working with China a little too much, maybe. Starting to see some jealousy, hate here going on with them. So just be on the eye with the Tesla, and just be cautious with them, and just be cautious with them. They got a lot of news. You really can't compete with Musk, man, and Musk I trust. So just keep in mind, just stay cautious with that. But the lawmakers are eyeing Tesla here, since they have been. Really, this is a short squeeze. They have been rallying up to the upside here in the past 7 days here, straight up, no downside at all. Little dips, then they take off. So that's just what it's been with them. And Amazon here, they still got that 20-to-1 stock split approaching here. I think it begins in May. I think this is just like they announced that they approved it. So it's a lot of hype with it. That's why the price is going back up. But once it starts, I think in May, that's when you'll really see this stock. Like it's going to put up numbers it never has ever seen before, because it's not going to do it again. It's going to reset, ladies and gentlemen. That is Amazon. And Google has the same thing going on with them right now. 20-to-1 stock split with Google. So they got the same type situation going on with them. Like I said, you're going to see them go up to numbers they've never been, because they're going to get reset to the regular market here. Share prices as in Boeing and like AMD and situations like that. You know what I'm saying? Airbnb, those type of share prices. If you go look those up, it'll be like matched with them. So ladies and gentlemen, Tesla had a stock split 4-to-1. They reset. So it is what it is with the Tesla. They already did their stock split. You can see where they're at now. Mr. 1K, and that just happened today, ladies and gentlemen. Congratulations. So it's lit here right now. But we're gonna take a lunch break. We're gonna tune into this briefing until lunch. But when this ends or when they take a break or whatever they got going on, this is day 3 of it. We're going to play some music and just continue to check and see if there's more news coming out here. The market is in the red, so you guys stay cautious. Try to get a dip. Try to get in there. It's really kind of a too late situation to be buying right now. So you want to, if you're buying right now, you want to buy a dip. Because like I said, it's too late. The market has shot up. The bulls have made their mark here. They have made the trend here. It's a bull market. So if you didn't buy at the low, you shouldn't buy at the high. I wouldn't be pressing that. I wouldn't be pushing for that. I don't tell people that. So I'm just like on the situation, hey, grab a dip. Hey, I told you it was possible, ladies and gentlemen. I told you anything's possible in this market. Like I said, it still really can go either way. This could be the top, though. It could be due for a pullback because of the rally. But at this point, I'm seeing pullbacks happen throughout the rally. So I'm not really thinking that's going to happen. I think the market is going to continue to go up here. It is rallying. We are just watching it happen. Numbers and charts are changing. So I'm reading that, going by that. That's what I believe. Keep in mind, that's what I believe. So I think the market is going to go up here, ladies and gentlemen. We're not going down. So overall statistics say war makes the market bullish anyway, ladies and gentlemen. So yeah, like with that being said, we're going to take lunch here, but we're going to continue to play this. And we'll see you guys here shortly, man. Enjoy your lunch. Enjoy this little break here. Get your mind off the stocks. Move around. Get your blood flowing. Kind of chill day here, but I like chill days, man. This is days where you learn, you catch discounts. Like I said, if you're buying stock right here, you can only just catch the discount here on this red day. If you're trading here, it's really you can make money both ways. If you're buying options here, ladies and gentlemen, you can make money all type of directions buying options. So keep that in mind, ladies and gentlemen. But this is the Stock Market Live with LCAOD. We're going to lunch, and we'll see y'all later.
Understand it. There are limitations in so far as there can be regulation of that right pre-viability unless the regulation imposes an undue burden on the exercise of the right. And there can be regulation after viability as long as there's exception for the health and I think maybe life of the mother. So it's the limitations are about whether and to what extent the government can regulate the right.
Is it your understanding under the current precedent of the Supreme Court that there is a right to abortion up to and including the time of delivery of the child?
Senator, I don't know, actually. I mean, the Supreme Court in every case is looking at individual regulations of the government related to individual rights. And I am not aware of the court having made a pronouncement about whether or not regulation can extend all the way up until birth. I'm just not aware of that. And that it's because the court is looking at individual cases and making its rulings in the context of individual cases and not making sort of pronouncements in general.
So you are suggesting that in some individual case, the right to abortion could extend through the entire pregnancy up until the time the child is delivered?
No, Senator, I'm suggesting that I'm not aware of any case that's handled the issue.
You told us that you think that you believe Roe versus Wade and Casey are precedents, and we talked a little bit about some of the questions about whether it's a super precedents and the like. Are you familiar with the Supreme Court's decision in the Heller case?
I am.
And that was a decision by the United States Supreme Court that recognized the individual right to keep and bear arms under the Second Amendment, correct?
Yes,
Is that a precedent of the court?
it is.
And you would respect that precedent?
Yes, Senator. All precedents of the Supreme Court have to be respected.
Is it equivalent in terms of its precedence to Roe versus Wade, or would you evaluate it differently?
I'm not aware of any ranking or grading of precedents. All precedents of the Supreme Court are entitled to respect on an equal basis.
I agree with you. That's why it kind of blows my mind when people talk about super precedents, as if somehow one precedent was different in terms of its significance or priority under the Constitution than others. In the short period of time I have remaining, let me just revisit with you some of the questions we talked about yesterday with regard to free exercise of religion. And of course, that's recognized explicitly under the United States Constitution, the First Amendment, correct?
Yes.
Okay. Are you familiar with the cases that have been litigated before the Supreme Court of the United States involving the Little Sisters of the Poor with regard to the Affordable Care Act mandate on contraception coverage?
Yes.
Now, the Little Sisters of the Poor are a benevolent group of nuns. I think there are about 300 of them that take care of elderly and infirm individuals. And of course, as a matter of their religious beliefs, as documented in the court's opinions, they don't believe in either contraception or abortion. Do you agree with that?
I believe that was described in the case that you're talking about.
I think that's right, too.
Yes.
Yeah. And so when the Affordable Care Act mandated that every health insurance policy contain coverage for contraception or chemically induced abortions, they objected and said that this violated their conscience and their free exercise of religion rights under the First Amendment, right?
I believe so, yes.
Well, after the Obama administration, during the Trump administration expanded the regulations to allow not only churches, but also religious organizations like the Little Sisters of the Poor a waiver from that contraception and abortion-inducing drug mandate. Do you recall that?
Yes.
Are you familiar with the fact that President Biden has said he would restore the previous regulation and that was promulgated under the Obama administration and exclude organizations like the Little Sisters of the Poor from that waiver potential for abortion drugs or contraception coverage?
I am not aware of that, Senator.
Well, I guess what all this boils down to, Congress passed a bill called the Religious Freedom Restoration Act, which tried to make sure that people's sincerely held religious beliefs could be accommodated under their First Amendment rights, as opposed to Congress mandating things that would violate their conscience and violate their religious beliefs. Do you agree with me that it's important to accommodate the sincerely held religious beliefs of all Americans when it comes to legislation that the Congress may pass?
Thank you, Senator. Religious freedom is a core foundational constitutional right. It's in the First Amendment of the Constitution and reflects the Founding Fathers' understanding of this country as being one that is based on in large part, the idea of pluralism, the idea that people can come and have sincerely held religious beliefs and practice them without persecution. That's part of the foundational foundation of our government and the amendment that you're discussing. And as a result, that right is protected in many ways. You mentioned the Religious Freedom Restoration Act.
Right.
Congress has enacted a statute that, when it comes to federal regulation, if there's a substantial burden placed on religion, then the strict scrutiny standard applies.
I agree. I have 1 minute, so I have one more
Yes.
question. I agree with what you just said.
Yes.
So since I have asked this question or made this point of some of your predecessors who sat in the same chair and expressed my concern about some of the court's establishment law, establishment jurisprudence, I don't want to leave you out of that concern. When I was Attorney General of Texas, I had a chance to argue a case in front of the United States Supreme Court and called Santa Fe Independent School District versus Doe. This was a lawsuit brought by the ACLU, which sought to enjoin or prevent a student-led prayer before football games at the Santa Fe Independent School District right outside of Houston. In the end, 5 judges said that that violated the Establishment Clause of the Constitution, causing Chief Justice Rehnquist to write in his dissent that the Constitution mandates neutrality toward religion, not hostility, but that the court's decision evidenced hostility towards religious expression, leaving me to conclude that the public square, we can talk about everything from violence to misogyny to sex, you name it, but we can't talk about sincerely held religious beliefs. I would just footnote that for you and plant the seed for what it's worth. Thank you very much.
Thank you.
Thank you, Senator Cornyn. Welcome to Majority Leader Schumer. Glad you're with us. And he would report, if he could, that we have a challenge to finish our hearing today at a time when we can go to the floor for a series of votes, which will end the day. So we want to stick to the schedule as much as we possibly can. I will just say that Senator Cornyn's suggestion of lunch was aspirational.
Okay.
It was an unenumerated right.
You're in charge of the agenda, Mr. Chairman.
What we had hoped to do was to take 3 more senators before we have an actual lunch. But it's up to you. Is that all right?
Oh, whatever you want to do. I'm open in here, happy to answer whoever would like to ask me a question.
Thank you. I appreciate that. Senator Whitehouse.
Thank you, Chairman. Judge Jackson, you can relax for a bit. I voted for you for the DC Circuit, and when you appeared as a potential nominee, we started doing work looking at your record and your story. We met with the president to discuss his process and his goals. When your nomination was announced, we obviously brought the work on your record more into focus, and now I've had the chance over, 15, 16 hours to see your performance in this hearing, which I think sets the gold standard for patience and courtesy. So I'm prepared to not only support you, but to let you know that I will be very proud and very honored and very excited to support you. There are 2 things that have come up during the course of the hearing, Mr. Chairman, that I'd like to take my time to have a chance to respond to. And the first has been a question, I've been through a bunch of these now. I don't think I've ever heard it come up so much. Questions about the nominee's judicial philosophy. I didn't know you needed to have one. I actually thought that when you're dealing with the Constitution, your oath of office, the constitutional precedents and the Constitution itself kind of gave you your guide path. And when you're construing statutes, the law and the conventions of the language and your logic gave you that path. So the fact that Judge Jackson has said, I don't have a judicial philosophy, I've got a judicial methodology, doesn't bother me a bit. In fact, it kind of bothers me the expectation that a nominee to the Supreme Court should have a judicial philosophy. Because a judicial philosophy can be a screen for a predisposition that judges frankly should not have, but that folks in powers and interests influential in the process may very well want them to have. So, you know, when I think about judicial philosophy, one of them that's come up a lot has been originalism. And one of the problems with the judicial philosophy is occasional adherence, selective adherence, which in my mind makes it less of a judicial philosophy and more of a doctrine of convenience to be trotted out when it helps the people that you want to help. And originalism strikes me as being that kind of a doctrine. And the place where I think we have the biggest gap between philosophy and practice in all of this has been with respect to what I've witnessed with respect to corporate power in our democracy in the time that I have been in the Senate. If you go back to the founding days, there was no expectation that corporations would have any role in American democracy. Nil. Doesn't turn up in the constitutional debates, doesn't turn up in the arguments leading up to the approval of the Constitution. It's only when corporations became big and powerful many decades later that they began to intrude in our politics, and they corrupted our politics in a terrible way, history shows. And that led to the movement by muckrakers, whose probably best leader was Teddy Roosevelt, to knock down the grasping political power of corporations and rein them in. And we had some real victories at that time, but ambitions of those of great wealth and power do not go away, and they have continually crept forward. It's an age-old story. And right now, we have corporate power controlling this Congress in a way that is really remarkable. We have a complete inability to address the climate havoc that fossil fuel emissions are creating because half of Congress has been disarmed and disabled by political influence of the fossil fuel industry. We can't even have a reasonable and sensible discussion on it because the power of that industry is so great. And we've seen that manifested first with Republican justices on the Supreme Court letting corporations into politics. That was an interesting invention. And then once they were in, they let them spend money in politics. And then once they let them spend money in politics, they let them spend unlimited money in politics. And now we are looking at a court whose majority is in the process of building a right for corporations, the biggest and most powerful corporations that we have, to not only get into politics, spend money in politics, and spend unlimited money in politics, but to spend unlimited money in politics anonymously, to hide from the real voters, the we the people, who they actually are when they're intervening in our politics, and to play this game through phony front groups with ridiculous names. Rhode Islanders for peace and puppies and prosperity, you know, sort of the quality of the name that's involved. So let's not get too excited about judicial philosophy if it's nothing more than a screen for a predisposition that will benefit certain players in the arena. And let's certainly not take judicial philosophy too seriously when it evaporates in the face of the interests that have pushed the philosophy. And I think originalism qualifies that way, and I just wanted to say that. I don't think you have to have a judicial philosophy. I think you have to have integrity. I think you have to have a judicial temperament. But a philosophy? Where has that come from? The second thing I want to say has to do with the question of court packing and the integrity of the court. And I have a position on this, and I just want to say it. So it's all clear, nobody's reading things into it that I don't believe, and I've had a chance to make my point here. And that is that court packing can be done by adding new seats to the court. I haven't proposed that. I think there's only one member in the Senate that has proposed that. It's gotten a lot of attention here, but I don't think it's been proposed here. But you can also pack a court by picking the justices. And in fact, there is a long, unpleasant American tradition of agencies being taken over by virtue of picking the members. It's called agency capture or regulatory capture. It goes back a long way. There is an abundant literature, both in economics and in administrative law, about capture. And there's nothing that makes a court immune to capture. That is why when I talked about this in my initial remarks, I said that the folks that have tried to capture the court have treated it no different than a 19th century railroad commission, because they were legendary for having been captured by picking the members who would rule for the railroad. And there are many others. Go back to MMS in the Gulf oil explosion. So that is my concern. My concern is that the picking of the justices has been handed to special interests. And we know that's the case because, as I showed yesterday, everybody involved admitted it. The President of the United States said so. The co-founder of the Federalist Society said so. A former chairman of this committee said so. And the President's legal counsel said so. And what happened in that process by which the justices were picked over at the Federalist Society? We don't know. There wasn't a poll that was taken of Federalist Society members.
You got half of Wall Street back here from lunch here, and you see the other half still in here listening with these people right here listening out for the Supreme Court confirmation hearing. Ladies and gentlemen, this is the Stock Market Live for LCAOD. We're back here from the break here. We're going to take a 30-minute lunch today, so like I said, on time, since I was running a little late due to some consultation or conference there with client. There's a couple clients. So, yeah, ladies and gentlemen, market is below VWAP right now. SPY below VWAP. Triple Q's coming back down to VWAP. VIX is chilling out a little bit right here, but it's up a little bit, up about 50% there in the VIX. So we are in the red here. NASDAQ down about 26%. Russell 2000 is down about 70%. You also have S&P 500 down about 62%. You got the Dow down about 94%, ladies and gentlemen. So we're getting a little pullback here in the overall market. And like I said, man, it's a buying opportunity. This is a dip, you guys. Until I can see further selling, I won't say, oh, we left the bull market, we're back in the bear market. And I won't say things like, oh man, this is about to get scary. We're up here at the top of the air. Like, nah, man, that bull rally was for a reason. And they're showing you that now it's sticking here. Of course, it's turning backwards here now. They just rallied for what I want to say at least that was either 6 or 7 days. The market just consistently went up here. So you got to expect what's happening now to happen here. Of course, people are going to take profits. So it's just things of that nature happening here. Like I said, I'm seeing an opportunity really on the swing. You can swing some things here. It might be best to wait here towards the end of the day, obviously, because there's a storm going on right now. It looks like they got the SEC up here today, and they're alert on everything. They got the market red right now. But like I said, it doesn't mean the rally is over here. It just means like it's a fire. You know what I'm saying? And they put the fire out here. You know how that go. When you put a fire out, it's just smoking, it's cool, and it's steaming off. So that's what we're getting here right now, ladies and gentlemen. That fire can get started any moment here again. Definitely by expiration on Friday. We got market data, of course, tomorrow, and the rest of the week here. It's going to be very important towards the market. Very important here towards the market. As you can see, I got pulled up. So Powell spoke this morning, 8 a.m. I think he got the market down here right now. So Tesla's coming down here below VWAP now. Looks like Waller speaks tomorrow morning at 9:10 a.m. And these are all Fed chair members anyway. This is member Williams. He speaks Friday. So this is really a member type week, Fed chair members type week. Waller speaks again on Friday at 12 p.m. So a lot of that going on, really. We did have some market data that came out this morning, but nothing to move the market. I think tomorrow is the big day. We got jobless claims, and Friday will be pretty big there. Yeah, we got jobless claims and all these Fed members speaking, so it's probably why it's boring right now. But other than that, we set a pullback here. The spot's coming down here again, right at the lower band here now on the spot. So yes, I'm seeing that momentum still with the bears right now, but overall we're in a bull market. Things have reversed here, ladies and gentlemen, looking at the charts and numbers. But yeah, that's just what it is here right now. So just like I said, it could be another dip opportunity here, or it might be best to really wait towards the end of the day, wait towards the end of the day. You just never know. Like I said, there's 2 more days left in this week to trade and buy shares. So anything can happen. That's running out of time, but still a little bit of time, if that makes sense. So just kind of be starting to think about what you want to do if you're holding, or you know what I'm saying, if you want to make a play or things like that. It's getting towards the end of the week here, basically. Keep that in mind, ladies and gentlemen. It is 1:06 p.m. and we're still listening to this here. As you can see, they questioning her, man. They've been questioning her for 3 days. I would be very exhausted here. I'm pretty sure that she's going to get a week vacation after this because, yeah, this is exhausting here. It's exhausting me. So I know it's exhausting her. Everyone asking her questions. So, yeah, ladies and gentlemen, let's just really continue to listen to this and have some respect for a sister here. No matter what she's trying to do, good or bad, let's just be happy that there's color finally in something that people like to say that there's not. Let's take advantage of that moment and celebrate for the sister and uplift her and uplift one another, not bring each other down. So let's tune in. We got her back here. We see they trying to rip her down with the questions, but it sounds like they just going through protocol. They got her back too. So let's just continue to listen here. Market is coming down though right now. So just be cautious here, you guys. Like I said, don't know how low they want to take it. Obviously, they can take it back to at least maybe half of this rally if they wanted to, but that's what I'm saying we haven't seen yet. We've just really been credit spreading in the channel on these red days, and on these green days, man, it's been going up. So that's what I've been noticing here. So keep that in mind, ladies and gentlemen. Stay cautious here. Stay cautious. Stay patient. Your opportunity is in front of you, but you have to stay patient. You want to enter at the right time. You don't want to FOMO. Money goes around and around for everybody. It's enough for everybody. Trust and believe. So just stay patient, you guys. Stay patient. It's bouncing right here. It's bouncing right here. The spot's bouncing. Let's tune back in, you guys.
When west of Colorado, the federal government owns more than 15% of the land, and most of the time it's a lot more. In my state, it happens to be about 2/3 of the land that's owned by the federal government. As a result, it complicates our ability to do just about everything we do, whether it's recreation, construction, oil and gas development, whether it's just accessing people's farms and ranches, or even something as simple as trying to fund local fire, police, search and rescue operations. All of these things are affected by the excessive ownership of federal land by the federal government and the way it's often managed. Sometimes decisions made at the federal level are challenged in parallel actions like these. One in the forum state, in the host state to where the action is happening, another in DC. And I'm always concerned about forum shopping. And I'm sure that's something you watched out for as a judge and saw forum shopping from time to time. It's also something that touches on an issue that involves statutory interpretation. There's something called the Antiquities Act, passed 110 years ago or so, designed to give presidents of the United States the authority to designate parcels of federal land as national monuments. The text of the statute states that the limits of the parcels in question should be, quote, confined to the smallest area compatible with the proper care and management of the objects to be protected. Now, given that these presidential proclamations tend to be broad, it's sometimes the objects to be protected are also broad. And as a result of that, it's difficult to tell what the limits are. Do you have any reaction as to how we could discern that, how we could define any meaning out of that? It's got to mean something. The text of the statute, you try not to leave language simply unaddressed or meaningless in a statute. Do you have any thoughts on how a statute like that, saying that it should be confined to the smallest area compatible with the proper care and management of the objects to be protected? Any thoughts briefly on that?
Well, Senator, if I were presented with a case with that statute in that circumstance, I would proceed as I always have. You would have to understand the parties' arguments about the particulars in the case. What does the presidential proclamation say? To what does it relate? Whether there are any precedents in this area that further define or further address what Congress intended with respect to the statute at issue.
And I would assume that it would also matter if the government's lawyers defending the president's action made an argument that would leave the interpretation open-ended and meaningless.
Well, as part of your interpretive exercise, as you're considering the parties' various arguments, one that did not account for all the words in a statute would be one that you would
Excellent.
might
Excellent.
not might not agree with.
No, I get it. And this is one of the things that I've appreciated about what you've told us in these hearings. I really like the way you've described the fact it's important to construe the text that you're asked to interpret. And in interpreting that, you look at the language and you're endeavoring to figure out the original public meaning. And I think that is a very helpful thing. All right, let's move to a different issue a moment ago. Now, you clerked on the U.S. Supreme Court for Justice Breyer in October term 1999, is that right?
That is right.
That was the same, and you clerked for Justice Breyer.
I did.
And that was the same year that the Supreme Court issued its decision in a case called Stenberg versus Carhart. This is the case where the Supreme Court of the United States struck down a Nebraska law prohibiting partial birth abortion. And in the absence of circumstances where the baby posed a threat to the life of the mother. Now, to be clear, the law prohibited a procedure where the abortionist causes an unborn baby to be partially delivered by the mother, and then the abortionist intentionally kills the baby outside the womb by puncturing its skull with scissors and then collapsing the skull. This is gruesome, and I don't like having to quote this, but it is relevant to the topic we're covering here. Justice Kennedy described it this way in chilling terms when in his dissent, when he describes the fact that when scissors are inserted into the back of the head, the fetus's body, wholly outside the woman's body and alive, reacts as though startled and then goes limp. Justice Scalia, in his great eloquence, expressed lamented the ruling, but also expressed optimism for the fact that future courts would get it right, saying, quote, "I'm optimistic enough to believe that one day Stenberg versus Carhart will be assigned to its rightful place in the history of this court's jurisprudence beside Korematsu and Dred Scott. This method of killing a human child, one cannot even accurately say an entirely unborn human child, prescribed by this statute is so horrible that the most clinical description of it evokes a shudder of revulsion." We then saw a few years later the Supreme Court of the United States issue a different ruling. The Supreme Court issued a different ruling in a case called Gonzalez v. Carhart. Gonzalez v. Carhart upheld a different statute. This one was federal rather than state, but it was a different federal statute that also prohibited partial birth abortion. Judge Jackson, can you distinguish these cases for me? What was the difference between Gonzalez v. Carhart, where the partial birth abortion ban in question was upheld, whereas in Stenberg v. Carhart, it was invalidated?
Thank you, Senator. I don't have the opinions in front of me. I think it had to do with the method of extraction, the fact finding related to the procedure. In one case, the district court had made some findings and the court felt bound by them. And another, there was considerations beyond those that were previously relied upon. So there were distinctions that the court looked at and considered in the cases, but yes.
Let's talk about court packing for a minute.
Yes.
One of the reasons court packing concerns me, one of the many reasons, is because it's not prohibited in the first instance. It's not prohibited by the Constitution. There's nothing in the Constitution that says that Congress may not change the size of the Supreme Court. There's no limitation on that. We have, for 152 years, stuck with the number 9. It has worked, and in the absence of an argument saying that that number is too low, the court is too small. From a workforce standpoint, we need to expand it. It's difficult to imagine why it would be a good idea to change it, particularly because if you increase the size of the court in one fell swoop, and you do that for partisan political purposes, allowing one president, the current president, to have a disproportionately impact on the court and to change its rulings, that portion of the court's docket that tends to be more politically contentious, it can turn the court into a political football of sorts. Given the fact that our Supreme Court justices serve for life, once you do that, it becomes something of a one-way ratchet, always expanding, never contracting. Before long, you could see an increasingly larger court, with the court expanding each time a different party secures the coveted circumstance of a majority in the House, majority in the Senate, and controlled by the same party of the White House. And so this is why it concerns me. I understand that why it is that the canons of judicial ethics don't allow you to comment on matters that might come before you. This is one that could not come before you as a justice. This is a non-justiciable political question. It's committed to the two political branches of government. There's not even a constitutional challenge that could lie to it, even though it would undermine the separation of powers in the Constitution as I see it. It's not unconstitutional. So it couldn't and it would never come before you. Last night when you were asked a question by my colleague, Senator Kennedy, on this, you acknowledged that you have an opinion. Did I understand that right? You have an opinion on court packing?
Senator, I have a lot of opinions. I have opinions on I'm a human being, and I have an opinion on a lot of things. The reason why, in my view, it is not appropriate for me to comment is because of my fidelity to the judicial role. I understand that it's a political question, and that is precisely why I think that I am uncomfortable speaking to it.
No, I understand that, and I respect the impulse. I respect the overall issue, and I think it's better for Article 3 judges and justices ordinarily to not wade into the political thicket. This one I do think is different because number one, as I say, it can never come before you. Number two, it does have an impact on what you would be doing, and you also as an Article 3 judge, someone who's served for nearly 9 years as a federal judge, you've developed experience and intuition and a thorough understanding of our federal court system. And that's why I think your perspective on it would be valuable. The reason it concerns me so much is that even when court packing doesn't succeed legislatively, it can leave an impact. The last time this was attempted was in 1937. President Franklin D. Roosevelt was upset at the Supreme Court on a number of bases. He didn't like the then 32-year-old precedent of Lochner versus New York, where the 5 conservatives on the Supreme Court engaged in an act of judicial activism, reading something into the Constitution that wasn't really there. Some people disagree with me on this, but it wasn't there. And they imposed that. But the bigger reason was he didn't like the court's interpretation of the Commerce Clause. It was that interpretation of the Commerce Clause, the one we discussed yesterday, prior to 1937, you had the Supreme Court agreeing as far as the channels and instrumentalities of interstate commerce that we talked about yesterday. You had the court more or less in agreement over time as to the impact of the Dormant Commerce Clause. But as to the substantial effects test, that didn't exist yet. It required something much closer to an interstate commercial transaction in order for Congress's Commerce Clause authority to kick in. There were the so-called 4 horsemen of the apocalypse, as FDR affectionately called them, 4 conservatives who were consistently pushing for limits on Congress's authority. And then you had other justices who would sometimes join with them. Usually that included Justice Owen Roberts, who had stood with them in maintaining narrower authority for Congress under the Commerce Clause. All that changed when on April 12th, 1937, 2 weeks to the day when the case often associated with the so-called switch in time that changed 9, West Coast Hotel versus Parrish, where they undid the Lochner precedent. April 12, 1937, the Supreme Court decided a case, NLRB versus Jones and Laughlin Steel, that forever changed and magnified, expanded the Commerce Clause in a way that had it been through a constitutional amendment, it would be among the most significant, impactful constitutional amendments ever adopted, and yet it's rarely discussed. This case resulted from one vote, one person on the Supreme Court who changed his vote, Associate Justice Owen Roberts. It's widely believed, and I believe it based on what I've researched on it, he was influenced heavily by FDR's court packing plan. He didn't want to be on a court that was packed. He didn't want, he convinced himself that he made that switch in order to save the court as it was. And that has changed everything. It's led to a much bigger, more expensive, more intrusive federal government. We can disagree as to the policy merits of that, but it did change the Constitution. That's why I worry about that. So I hope, I understand you don't want to answer it. I hope that between now and the end of the day, you'll see fit to tell us what your opinion is. I do think it's worth discussing. Let's talk for a minute. Got just moments left. I want to get back to your sentencing approach. Now, when you approach these child pornography cases, what you're describing in many circumstances is an overall concern that you've got with the sentencing guidelines, and particularly that portion of the sentencing guidelines that deals with child pornography cases. This showed up in the transcripts of some of your sentencing hearings, including the transcript of your sentencing hearing in the Hawkins case. I turned to that to page 38, lines 17 to 24 of that transcript, and here's something you say in that Hawkins case. And I believe this was the 18-year-old defendant that you sentenced to 3 months in prison, when the lower end of the guidelines range would have been 97. I think the higher end would have been in the 120s or something like that. You said, and in your case, this is you speaking to Mr. Hawkins, in your case in particular, I don't feel that it is appropriate necessarily to increase the penalty on the basis of your use of a computer or the number of images or prepubescent victims, as the guidelines require, because these circumstances exist in many cases, if not most, and don't signal an especially heinous or egregious child pornography offense. I've got a couple of questions about that. Were those, you start out that paragraph sounding like you're making a determination as to him, but then the observations you make in that paragraph seem to apply broadly. Is that right? So what?
Senator, I don't have the transcript of Mr. Hawkins' case. I recall that I found that case, like all child pornography cases, to be difficult, really difficult. And his case, I recall, was in many ways an outlier in terms of the various considerations that Congress required me to take into account.
But there were prepubescent victims that were at stake in that.
I don't remember how many. I don't remember the circumstances of his actual crime. What I will say is that, consistent with Supreme Court case law and Congress's statute in this area, judges have to take into account a number of factors and the guidelines, which are no longer, I won't say not mandatory. You have to calculate the guidelines. They're no longer binding. And the Supreme Court has said that under the statutory scheme, judges have discretion.
But Mike, I'm almost out of time.
Yes.
I want to make a point.
Yes.
Hawkins, as I recall, and as Senator Hawley discussed yesterday, he specifically asked for images of 11 to 17-year-olds. So I don't understand how that can be an instance where that shouldn't matter, and where the fact that he did it with a computer hardly atones for what he was doing, hardly offsets the fact that he was seeking and obtained prepubescent child pornography images. Nor does the fact that the images become easier over time to transmit and receive and store because of computers. I actually think it cuts in precisely the opposite direction that you described. It makes it more severe, not less. I see this as an aggravating factor, and that is of great concern to me. I see I've exceeded my time. Thank you.
You may respond.
Senator, as in every child pornography case that I sentenced, I considered all of the evidence, all of the relevant factors. It is not the same exercise to look at a transcript, to think about guidelines, to not have in front of you the individuals, the victims, the pictures, the circumstances that trial judges have to review in these cases or any cases. I understand, Senator, that there are some questions about records, etc. Courts have all of the evidence, and courts have all of the recommendations of various parties, and courts have, under Congress's authority, the responsibility of using our judgment to make determinations that are sufficient but not greater than necessary to comply with the purposes or promote the purposes of punishment, taking into account things like unwarranted sentencing disparities. And it may seem like an easy exercise. It may seem in retrospect, when you look back at a few pieces of data, that courts have not done what it is that they're supposed to do. But what I can assure you is that I took every one of these cases seriously in my duty and responsibility as a judge, and I made my determinations in light of the seriousness of the offense, the nature and circumstances of the offense, the history and characteristics of the defendant, the need for the sentence imposed to promote various purposes of punishment, and all of the other factors that Congress prescribes.
Okay, but you keep resetting that standard, and yet you specifically excluded from consideration the fact that he had requested and obtained images, prepubescent child pornography images.
Senator, I didn't exclude it. I didn't exclude it. What I did was I looked at the guidelines, which is what the Supreme Court requires, and I was making policy determinations as the Supreme Court says that judges are to do.
Look at
in
page
these
38
situations.
of your transcript. It looks to me like you excluded it, and your action sentencing him to 3 months for one of the most heinous offenses imaginable. Keep in mind, because these are transmitted
Senator,
electronically, they're there for years. They re-victimize these victims
Senator,
the rest of their lives.
we're asking everyone to try to stick with the 20 minutes, please. Next is Senator Klobuchar, but before recognizing her, I'd like to ask consent to enter into the record a support letter for Judge Jackson from 48 former federal prosecutors in South Florida. Without objection, Senator Klobuchar.
Thank you very much, Chairman Durbin. Welcome back, Judge Jackson. Yesterday, you and I discussed the court's increasing reliance on issuing unsigned orders on its shadow docket. And less than an hour ago, the court once again used the shadow docket to throw out Wisconsin's redistricting maps. And because this decision just came out, I don't expect you to have immediately reviewed it. But I just want to make this point that in her dissent, Justice Sotomayor, joined by Justice Kagan, called the court's move unprecedented. She noted that in an emergency posture, the court summarily overturns a Wisconsin Supreme Court decision resolving a conflict over the state's redistricting, a decision that was rendered after a 5-month process involving all interested stakeholders, based on an obligation that is, these are her words, hazy at best, even though summary reversals are generally reserved for decisions in violation of settled law. And again, I don't expect you to be familiar with this case, but I do want to point out that this underscores the point that I made yesterday, that the court's increasing practice of using the shadow docket to decide cases that have grave consequences for our democracy, including the right to vote, that you and many other nominees have said is fundamental, is incredibly troubling. You had in the other case I mentioned yesterday where Justice Roberts dissented, the Texas abortion bounty hunter case, that should not have been done on the shadow docket. And while I'm not going to ask you about this because you couldn't possibly have read it, just your record of writing decisions that are thorough and listening to litigants in cases, could you just generally talk about the importance of having full briefings on the merits as well as public oral arguments if you believe in transparency?
Thank you, Senator. As a judge in my work over the last decade, I've seen that it is very important, at least to me in my time as a judge up to date, to hear arguments from all sides in a case. The duty of a judge is to make determinations, and under our system of adversarial proceedings, you make determinations based on arguments, and it's important to do so. I know that with respect to the emergency docket, you haven't asked me the question about it, because I would say what I said before, which is I would benefit from being able to speak with the justices. I understand that there's a need to balance getting full briefing with emergency circumstances, and the court has long had in its procedures the ability to rule quickly on various cases. It's also my understanding from my time clerking on the court that the court does recognize the value of allowing things to what we call percolate, meaning lower courts to hear issues. And my understanding is that at least in some of the recent cases, the justices have had oral argument related to some emergency matters. But from my perspective as a judge in the work that I've been doing, I know that it's important to hear from the parties.
Another hallmark of your work has been taking complex issues and making them accessible to the public. So much so that I actually referred to one of your opinions from a debate stage in Los Angeles, saying, as a wise judge said, those were my words, I guess I was ahead of my time, the president is not king in America, the law is king. I paraphrased it. That was a written opinion that you wrote that was over 65 pages long, relied extensively on Supreme Court and circuit precedent. It was Committee on the Judiciary v. McGahn. And could you talk about really two things, the importance of having the law written in terms that are easy to understand by people, and then secondly, your opinion was actually a narrow one. It required Mr. McGahn to appear to testify, but that said he remained free to assert any legally applicable privilege in response to the questions asked. So what you did there was a narrow opinion. What role do you think that narrow rulings play in helping to maintain the legitimacy of the court? Why is it important to have plain language in orders?
Thank you, Senator. Well, I'll start with the second first. I think that, as we've been discussing, we have a rule of law in this country which requires a certain amount of predictability and stability in the law. If there are big shifts in terms of legal principles and doctrines and whatnot, it could lead to people not understanding that judges are ruling on legal principles. It could lead to undermining public confidence, thinking that judges are injecting their own policy preferences rather than following the law in terms of their rulings. And so to further predictability, stability, there are many doctrines in judicial practice. There's stare decisis, which is the principle that if something has already been decided, very similarly, you at least if it may be binding on you if you're a lower court, but at least you have to contend with it because that is the law that existed before you got the case, and you don't want to make a big shift. And then there's also the principle that the understanding that when you are announcing rulings, you are building on what exists before, and so you don't want to make a big shift if you don't have to, because if you can find a way to rule incrementally in a more narrow way, it keeps the law stable. Is a part of the proposition that I mentioned before. In McGahn, in particular, it was a case in which there was a precedent directly on point from my district. It was not binding on me, but the exact same set of circumstances and arguments had been presented to another judge in my district. I believe it was something like 10 years prior to my case. And so we had law that governed the circumstance, and I looked at that, determined it was persuasive, and that I should continue the principles that had been laid down by in the prior case. Also, in accordance with those principles, the prior judge and I made the determination that when the president claims absolute immunity, the argument was that the person who had been subpoenaed by the legislature, a former employee of the White House, could say that they had immunity of some sort. In other words, it could have invoke executive privilege in response to particular questions, but they couldn't say, I don't have to show up at all. And so the argument that was being made was when the House of Representatives issues a subpoena and says, show up on this day at this time to answer questions, can that person just ignore and say, I have immunity, I don't have to follow the law, in other words, respond to the subpoena? Or do I have to show up and sit there and listen to the questions? And if there are things that I believe I can't answer because they're privileged, then you invoke the privilege. And the prior case had said in this narrow way, you have to show up. You don't necessarily have to give the information. That's determined on a question by question basis, but you have to show up. And that's what I held in that case as well. And it's important to be clear in your rulings so that people understand that judges are ruling consistent with the law and not their own personal views.
Right. And speaking of being clear and being careful in your rulings, some of my colleagues have, I think, given not a necessarily true view of your whole record, because when it comes to your rulings being upheld, the numbers show that out of over 550 cases, your district court cases, you were reversed less than 3% of the time. And in some of the instances, you were reversed only to have your decision later upheld. I noticed one case, Territory of Guam v. United States, in which you were initially reversed, but then a unanimous Supreme Court reversed that decision, then siding with you in an opinion written by Justice Thomas and aligned with your view. Do you want to quickly talk about that case?
Well, that case is kind of legally complicated. It was a CERCLA case, which is a Superfund cleanup kind of case where the country of Guam, which has a dump site on it that was used by both the citizens of Guam and the United States before the 1950s, when the United States was stationed there. Military operations happened out of Guam, and there was a lot of dumping into this site. And over time, the site got contaminated, and Guam was charged with having to clean it up, which is millions and millions of dollars. And there are statutes, very complicated statutes, about the circumstances under which you can seek contribution, under which a country like that can ask for the United States to pay some of that cost, or other countries to pay some of that cost. And that was sort of the nature of the dispute. And I did a statutory interpretation about whether or not Guam's action could proceed. The United States filed a motion to dismiss, saying that all of the technical requirements of the law weren't met and that the action had to be dismissed. And I denied the motion to dismiss after interpreting the statute, saying that the action could continue. The DC Circuit reversed my view, had a different reading of the statute, saying that the motion to dismiss should have been granted, and dismissed the case. And then it was appealed to the Supreme Court. And as you say, the Supreme Court reinstated the action, saying it could proceed.
Very good. Thank you. In 1972, in Brandsburg v. Hayes, a 5-4 court did not recognize the reporter's privilege in the context of criminal grand jury testimony. And I spoke with you earlier at length about Times v. Sullivan and First Amendment issues, so this will be my last question on this. Since the court's decision, my state, like many other states, enacted strong reporters' privilege laws to protect journalists from having to divulge unpublished materials, confidential sources. How would you approach balancing the need to protect journalists and the role they play in informing the public against the need for law enforcement officers to gather information?
I would apply the precedents of the Supreme Court in this area. It would depend on the circumstances. As I mentioned, press freedoms is one of the fundamental First Amendment rights. the court has a number of precedents in terms of expressive freedom, press freedom, and in every case, there'll be a specific set of circumstances regarding an alleged violation of the right, and the court would need to look at the facts and circumstances, the prior precedent, in order to determine whether that particular regulation could be upheld.
Okay, thank you. This is my very last question, Chair, before all of us get to eat lunch, including you. And that is really the important role of dissenting opinions. Justice Ginsburg once said this. She said, "Dissents speak to a future age. It's not simply to say my colleagues are wrong and I would do it this way, but the greatest dissents do become court opinions, and gradually over time their views sometimes become the dominant view." When Justice Ginsburg's rabbi gave a eulogy at her memorial service here in the Capitol, and some of us were fortunate enough to be there. They said, "Justice Ginsburg's dissents were not cries of defeat. They were blueprints for the future." What do you think is the purpose of a dissent? And you want to talk just a little bit about that, this idea that they can be blueprints for the future?
Thank you, Senator. On the Supreme Court, there are 9 justices, and in every case, they're all sitting together to hear the issues in a case. And one hopes, and it often happens, that the justices agree as to issues in cases. That I believe that the vast majority of cases that the justices hear are actually not, there is no dissent, that they agree to the outcome. But there are cases in which, after deliberation and collaboration and consideration, the justices may disagree about how the case should be resolved, and there's a mechanism for every justice to decide whether they're going to join others, either in the majority, whether they're going to write a separate opinion that might agree with the majority but wants to make a different point, or whether they want to dissent. And sometimes more than one justice might dissent or join a dissent. It's a way of expressing one's own view that may differ from your colleagues. And with respect to the point that you made, there are actually many justices in history who have used the dissent mechanism to discuss the law in ways that others find over time to be more persuasive. And so I'm thinking of the first Justice Harlan, who dissented famously in Plessy versus Ferguson. He dissented alone. All of the other justices agreed with the proposition of separate but equal, and he said no in a dissent. And his dissent, generations later, became, according to Justice Thurgood Marshall, became the blueprint for Justice Marshall to make arguments that led to Brown versus the board. So there is the opportunity for justices to describe their views in ways that become persuasive to others in the future.
Thank you for all you've given us the last few days. We look forward to working with you. Thank you.
Thank you.
Thanks, Senator Klobuchar. And we're going to break now for a 30-minute lunch. I'd say to everyone that when we return, if we stick to 20-minute rounds and don't yield back time, we'll be finishing in something around 4.5 hours, which would take us to about 7 o'clock. So that doesn't include a break, but we'll consider that later on. Thank you, Judge, again.
And with that, Chairman Dick.
All right, ladies and gentlemen, as you can see, the market is coming down now. So they're gonna take a break there. As you see, this crew is gonna take lunch now. One half of the crew already took lunch. The market's just coming down now. It looks like a pullback though. It doesn't look like it's gonna sell off here. It looks like a pullback to me. I like it. Keep in mind, I like it. I like it. I like it. I like it. Like I said, they're providing opportunity, man, for the names that's been running. They're giving you a discount, you guys. Like I said, you had the ultimate discount when it was at the bottom here, and now the market is kind of up here. So if you wasn't buying at the bottom, you gotta buy it on the dips now. You have to. Even if the dip is not your dip, you still gotta just take the risk here. And just give it some time, have some patience, man. Like I said, today's a red day, obviously. When we get a green day, obviously stocks are gonna be up here. Just, you know, business. It's all business. In politics here, they stepped in. Obviously the market was rallying here for about 6 or 7 days straight. Somebody got tired of losing some money and somebody told on somebody. You see what I'm saying? So now we're just having a dip type day, and it's just what it is here. Looks like we do have some more market data going on here. Live. This is Justin Trudeau addresses European Parliament, and it looks live here. So let's see what they're talking about here with that. So yeah. I'm in a little straddle here. Nice straddle going on here with advanced medical devices here. Nice little straddle here. Got some news on them. They're playing. Everybody's playing here. So a lot of people, smart money, just trying to follow smart money. They got some news with them coming out soon, about a couple weeks. So this is a little short mid-term play, a little short long-term play. What to call these right here. But you know, you always want to get cover. That's really what it boils down to, covering. You know, cover things look your way. That is for sure. That is for sure. So yeah, ladies and gentlemen, I'm trying to see what this briefing was. Okay, so I got it. I got news on it now. It's the Canadian Prime Minister. It looks like this just might have started too. Let's see. Yeah, it looks like it did here. It started about 59 minutes ago. So let's tune in and see what this is about.
For our citizens, it's not a question of availability, but affordability. While there is enough food and in the EU, prices are rising. Food inflation reached 5.6% compared to February 2021. We must protect lower income citizens and vulnerable families. We must remember that in the last 3 weeks, our population has grown by more than 3 million people. That is more than 3 million extra mouths to feed every day. The Commission calls on Member States to use their social policies to protect vulnerable citizens from food insecurity. Member States can also implement reduced rates of VAT on food and use the fund for European aid to the most deprived. For farmers, it is not a crisis situation, but critical situation, especially for a number of specific sectors and smaller family farms. Let me briefly outline what this communication holds for farmers. Firstly, the Commission has adopted exceptional support measures of 500 million to directly assist those farmers most affected by the higher input costs and the closure of export markets. The Commission will submit its proposal to use the crisis reserve for this support package to both the European Parliament and the Council. Member States can exceptionally complement this EU support by up to 200% with national funds. In addition, the Commission will allow Member States to pay increased levels of CAP direct payments in advance to address the cash flow difficulties that farmers are facing. We have also adopted an exceptional temporary derogation to allow the production of any crops on fallow land this year, while maintaining the full level of greening payments for farmers. In view of the particularly difficult situation in the pigmeat sector, the Commission will open a new private storage aid scheme to stabilize market. Member States can also measure at national levels. A temporary crisis framework for state aid has been put in place to allow Member States to grant direct aid to producers affected by crisis and to energy-intensive undertakings such as fertilizer manufacturers. Finally, some Member States have started to use the specific flexibilities to existing import requirements related to pesticides for animal feed, provided that safety is ensured. We must act with these measures in the short term to address food security and affordability concerns now. Let me remind you that we do not currently face a food security threat in the European Union. It is simply prudent that we support our farmers to produce more food sustainably while they can. That is why the Commission is acting with these short-term measures. Let me say one word also on fisheries, which is, of course, equally part of our food system. The EU fishery, aquaculture and processing sector is also directly affected by the disruptions of the market. Contrary to agriculture, the European Union is not self-sufficient when it comes to seafood. We are very much import dependent, including as regards imports of raw materials for fish processing. The sharp rise of marine fuel prices makes most fishing fleet unprofitable. The fisheries sector will benefit from some measures I just mentioned, including the temporary crisis framework for state aid. Let me say this clearly. Fundamentally, the transition to sustainable agriculture, as envisaged in the Green Deal and Farm to Fork, is our only path to food security. This is strongly recognized and reinforced in our communication. We must also ensure that our food system is resilient to external shocks, like the one we are now experiencing. This is why the Farm to Fork strategy is an important part of our response. It sets the path to reducing our dependence on inputs like fertilizers without undermining productivity. This will require a greater use of knowledge sharing and innovation in areas like precision farming, organic farming, nutrient management and agroecology, which must be facilitated through CAP strategic plans. On the subject of the CAP, the Commission will address the Russian invasion of Ukraine in its letters of observation to the CAP strategic plans, which will be adopted next week. I have called on Member States to use their strategic plans to strengthen the sustainability and resilience of their agricultural sectors, reducing energy, pesticides, and nutrient dependence, and prioritize actions that increase yields sustainability. The Commission will support Member States who, for example, use funding to boost sustainable biogas production, improve energy efficiency, foster bioeconomy solutions, convert into organic farming, protein crop production, and develop their knowledge and innovation systems. In conclusion, honorable members, I am confident that while we face a significant challenge, we can overcome it. But we need to act together within the European Union and with our international partners. I know I can count on the loyal cooperation of this House to face this crisis together, to address the challenges we are confronted with, and to preserve our long-term strategy, making our food system more sustainable and resilient. Thank you very much.
Danke sehr.
Nun sind die Sprecher und Sprecherinnen der politischen Fraktionen zu Wort gemeldet und als erstes der Abgeordnete Herbert Dorfmann für die EVP. Bitte.
Danke, Frau Vorsitzende, Herr Kommissar, geschätzte Kolleginnen und Kollegen. 43 Milliarden Euro. So viel wiegt der Sonderplan der Kommission zur Bewältigung der Versorgungskrise mit Chips. Mit 500 Millionen Euro, die übrigens schon in der GAP als Krisenreserve vorgesehen sind, also schon Geld der Bauern sind, will die Kommission nun die Lebensmittelkrise lösen, die klar und deutlich auf uns zurast. Das hat auch die Präsidentin von der Leyen heute hier schon gesagt. Das bedeutet also, dass ein fehlender Chip genau 100-mal wichtiger ist als ein leerer Teller. Und ich bin gespannt, ob die Bürger der Europäischen Union das dann auch so sehen werden. Deshalb gut, dass die Krisenreserve, Herr Kommissar, aktiviert wird, aber das kann nur ein Anfang sein. Es wird wahrscheinlich mehr Geld brauchen. Gut, dass unsere Bauern auf den ökologischen Vorrangflächen anbauen können, aber es ist ein Tropfen auf den heißen Stein. Gut, dass wir bei Importen flexibel sein wollen, aber was wir importieren, wird letztendlich in anderen Ländern fehlen. Wir müssen diese Versorgungskrise antizipieren. Wir müssen dafür sorgen, dass der interne Markt funktioniert, dass nicht weitere Dinge passieren wie mit Ungarn, wo Exporte verboten werden. Wir hatten gestern im Agrarausschuss ein Treffen mit dem ukrainischen Landwirtschaftsminister. Und obwohl Krieg ist in der Ukraine, müssen wir alles tun, damit die Bäuerinnen und Bauern in diesem Land auch dort produzieren und anbauen können. Sie brauchen, wie Sie gesagt haben, Treibstoff, Pflanzenschutzmittel, Dünger. Wir müssen diese Produktionsmittel nun ankaufen und versuchen, in die Ukraine zu liefern. Und zwar sofort. Die Aussaat beginnt in wenigen Wochen. Dazu brauchen wir grüne Korridore von der EU in die Ukraine. Wir brauchen also einen wirklichen Plan. Was wir nicht brauchen, Herr Kommissar, sind Gesetzesinitiativen der Kommission, welche die Lebensmittelsicherheit weiter gefährden. Die können auch warten, bis wir diese Krise überstanden haben. Das wird leider einige Monate dauern. Wir müssen also jetzt handeln, sofort und entschieden. Herzlichen Dank.
Danke sehr. Als nächstes zu Wort gemeldet für die sozialdemokratische Fraktion für 3 Minuten Irache García Pérez. Bitte.
Gracias, presidenta. La tensión y la incertidumbre que vivimos estos días en Europa no tiene precedente en medio siglo. Y sin embargo, yo hoy quiero lanzar un mensaje de tranquilidad a los europeos y europeas. La Unión Europea está preparada para hacer frente a los efectos de esta guerra y asegurar que no habrá escasez de alimentos. Y esto es así porque llevamos mucho tiempo preparándonos. ¿Quién nos iba a decir que 60 años después de que se creara la política agrícola común nos encontraríamos en esta situación? Sin duda, la PAC ha sido uno de los mayores logros de la Unión Europea. Durante la crisis del COVID ya vimos la resistencia y la capacidad del sector alimentario europeo, a pesar del nerviosismo de algunos al principio que intentaban hacer acopio de alimentos. Ahora bien, la COVID ya sometió a una gran presión al sector de la alimentación y a la cadena de distribución. Hicieron un enorme esfuerzo por garantizar el suministro en toda la Unión y ahora necesitan todo nuestro apoyo. Los sectores agrícola, pesquero y ganadero se enfrentan a los altos precios del combustible y a la dificultad para importar piensos y fertilizantes. No es un debate nuevo, señorías. En esta misma Cámara ya hemos hablado desde hace varios años sobre las medidas necesarias. Precisamente, las estrategias del Pacto Verde Europeo y de la granja a la mesa pretenden ayudarnos a producir de manera sostenible, reduciendo nuestra dependencia de petróleo, de gas y de fertilizantes. La guerra en Ucrania solo confirma las decisiones que ya habíamos tomado y nos obliga, por un lado, a acelerar el paso y, por otro, a fortalecer los sectores afectados. Es el momento de evaluar el impacto de la guerra en las políticas y ajustarla para asegurar que se mantiene la producción, pero también que los agricultores, los pescadores, los ganaderos mantienen sus ingresos. Algunas ganaderías pronto tendrán problemas para alimentar a sus animales. Esperamos con urgencia esta propuesta de la Comisión para asegurar el pienso. El gran reto para nuestra agricultura será cortar la dependencia de los fertilizantes que importamos de Rusia y Bielorrusia, de los que difícilmente podremos prescindir a corto plazo. Debemos intensificar la búsqueda de alternativas. Al mismo tiempo, debemos asegurar liquidez a los agricultores y a los ganaderos con flexibilidad que ya permite la política agrícola común. Hagamos uso de la reserva de crisis, pero pensemos al mismo tiempo en el futuro. Hemos de usar todos los mecanismos disponibles en la organización común de los mercados agrícolas para estabilizar los precios, evitar la especulación y asegurar un precio decente tanto a los productores como a los consumidores. Y además de los transportistas, el alto precio del combustible también afecta al sector pesquero. Y para ambos es necesario encontrar apoyos. Como decía al inicio, hacemos un gran esfuerzo colectivo, pero tenemos todos los instrumentos para afrontar esta crisis. Otros no. No lo olvidemos. La irresponsabilidad de Putin solo nos obliga a ser solidarios y a garantizar alimentos para Ucrania y para los refugiados, sino que también debemos de ser conscientes de las consecuencias globales. No podemos resignarnos simplemente a que la brutalidad de Putin haga descarrilar el segundo objetivo de desarrollo sostenible de la ONU, la erradicación del hambre. Señorías, ante retos de esta magnitud no hay atajos. Mirar hacia otro lado no nos hace avanzar. Solo el paso firme, la unidad y la confianza de estar haciendo lo correcto. Muchas gracias.
Dankeschön. Als nächste zu Wort gemeldet ist für die Fraktion Renew Ulrike Müller. Bitte. 1 Minute.
Frau Präsidentin, Herr Kommissar, sehr geehrte Kollegen, der Angriffskrieg Russlands in der Ukraine verschärft die ohnehin schon angespannte globale Lage mit Blick auf die Ernährungssicherheit auf drastische Art und Weise. Der Vorsitzende der des Ernährungsprogramms erwartet im Lauf des Jahres eine regelrechte Hungerkatastrophe in der dritten Welt. Dies sind alarmierende Aussagen. Wir in der EU haben eine Produktion.
And now Senator Graham.
Thank you, Judge. Again, congratulations. I want to talk to you a little bit about family and faith because in your opening statement, the people who introduced you to the committee, there was very glowing praise of you as a person, a good friend. You have a wonderful family. You should be proud, and your faith matters to you. What faith are you, by the way?
Senator, I am Protestant,
Mhm. Okay.
non-denominational.
Okay.
Hey, everybody. It is
Gabby Giffords.
and Mark Kelly. Hey, and we're sending this message to you because we got to raise a little.
So, all right, ladies and gentlemen, yeah, that coverage is going to begin back here shortly. As you can see, the market is down here. Looking at the discount, U.S. government formally accuses Russia of committing war crimes in Ukraine. So the U.S. government formally accuses Russia of committing war crimes in Ukraine. The Dow's down 97, SP 500 is down 88, Nasdaq's down 88, Russell 2000 is down 1.37, VIX is up 2.27, so the VIX is going back up here. Looks like off of that breaking news headline, we're going to resume that shortly here. Looks like this is still going on, maybe, or just ended. Oh, just ended there. So nothing going on right now. So we're still live here, ladies and gentlemen. This is the Stock Market Live with OCLD. We're going to take a quick break here. Hold up. What State Department spokesman Ned Price is holding a briefing, ladies and gentlemen, and this is live. Looks like this just kicked off, so we're not actually going to take a break. My bad. We're going to go live right here with that.
Just saw from Secretary. So without further ado, Ambassador Vance Cox. Thank you.
Good afternoon, everyone. I really appreciate the opportunity to address you here today as the Ambassador at Large for Global Criminal Justice. The office that I lead, the Office of Global Criminal Justice, provides advice to the Secretary and to other department and interagency leadership on issues related to genocide, war crimes, and crimes against humanity. As the Secretary noted last week, our office is leading the department's efforts to collect, analyze, and document potential war crimes being committed in Ukraine. Earlier today, Secretary Blinken issued a statement announcing that based on information that is currently available, the U.S. government assesses that Russia's forces are committing war crimes in Ukraine. I wanted to provide you with some additional information underlying this assessment. We have all seen really horrific images and accounts from the extensive and unrelenting attacks on civilians and civilian sites being conducted by Russian forces in Ukraine. There have been numerous credible reports of hospitals, schools, theaters, etc., being intentionally attacked, as well as indiscriminate attacks. Russia's forces have destroyed apartment buildings, schools, hospitals, other elements of the critical civilian infrastructure. We've been shocked by images of Russian forces and strikes hitting civilian sites in Mariupol, including the maternity hospital, a museum, and an art school. The United Nations and other credible observers have confirmed hundreds of civilian deaths, and we believe that the exact civilian death toll will be in the thousands. Last week, Secretary Blinken expressed his view that some of Russia's reported attacks did in fact constitute war crimes. He emphasized that the Department of State and other U.S. departments will be documenting and assessing the facts and the law surrounding these reports. The assessment has now concluded with a careful review of currently available information, both public and from intelligence sources. This review underpins the assessment that the Secretary announced today, that Russian forces are indeed committing war crimes in Ukraine. As with any alleged crime, ultimately it will be for a court of law to determine individual criminal responsibility, who is directly responsible for these particular cases. The U.S. government will continue to track reports coming out of Ukraine of war crimes, and we will share this information with our friends and allies and with international and multilateral institutions as appropriate. We are also supporting the Ukrainian Prosecutor General's Office and their War Crimes Directorate and supporting civil society documentation efforts. I want to reiterate our solidarity for the people of Ukraine. We are committed to pursuing full accountability for war crimes in Ukraine using all of the tools that are available to us, including criminal prosecutions. As the Secretary said, those who are responsible for such abuses must be held accountable. So with that, I would welcome some questions.
Thanks. Thank you, Ambassador, and welcome. Congratulations on your confirmation. I'm just curious, in terms of the information that you say that you're collecting or have collected and are going to share with partners, allies, international institutions, where exactly do you think the accountability here is going to come from? It does not appear likely, or in fact, it's impossible, basically, that any kind of UN mandated or UN approved court will take this up, considering it's got to go through the Security Council and Russia will veto it. So where exactly are you expecting accountability to come from?
Obviously, we are going to be considering all the options that are available to us, including domestic courts. Obviously, we have the courts in Ukraine itself as the territorial state, and the Prosecutor General's Office does have a War Crimes Directorate. Some funding from the Office of Global Criminal Justice is supporting efforts to build capacity within that office and help them do these cases ultimately if and when they have custody over particular perpetrators. In addition, third states within the region who may gain custody over perpetrators or potentially be able to do in absentia trials would have jurisdiction over war crimes committed within Ukraine. And then we welcomed the fact that the new incoming prosecutor of the International Criminal Court has also opened an investigation into the situation within Ukraine. So there are some options for accountability, even absent a dedicated tribunal, as you mentioned.
Michelle.
Court, and the previous administration even had sanctions against the ICC. Are you cooperating with the new prosecutor of the ICC?
I think everything's on the table. We're considering all the various options for accountability. There have been no specific asks. I do understand that the prosecutor has been meeting with the Assemblies of States parties, which are members of the court, and may have specific asks for those members who have cooperation duties towards the court. But as of a non-state party member, we're not a member of the court, and so we don't have any affirmative cooperation duties.
Vivian?
Thanks, thank you, Ambassador. Just for the folks at home, on a practical level, what the immediate impact of such a designation would
would be? What changes and how can this potentially help the Ukrainian people, if at all? Thank you.
Right. I think it's incredibly important to shed a light on what's happening within Ukraine so that the people of Ukraine understand that the world knows what they are suffering and that they're suffering at the hands of an aggressive war that was launched unprovoked by Russia. It's also extremely important to continue to document what's happening on the ground, to preserve that information as potential evidence for future accountability purposes. We don't want to lose that evidence. We don't want that evidence to be tampered with. So it's extremely important that it be collected now and preserved with an eye towards future accountability.
Paul, the Secretary of State listed a number of incidents, but he didn't say these were specific to what your war crimes allegations are. So what specific instances are you looking at?
So I actually can't get into those specific instances, but know that we are looking at the broad range of activities that the Russia's forces are engaged in within Syria, and we will continue to do that going forward. But we don't want to get into a situation where we have to make an independent assessment and then a public announcement every time there's an incident. This is going to be an ongoing process throughout this conflict.
The public very interested in this bombing of the theater in Mariupol. Is that one of the ones you're looking at?
That's obviously an extremely important and it appears to have been a direct attack upon a civilian object.
Yeah, just to probe into that a little bit more. In terms of the Secretary is saying these appear to be deliberate targeting of civilians. Is there anything you can say about evidence you've gathered or evidence you've seen that aside from the bomb fell on the theater that had the word children written outside of it, but I guess in a court of law, what is there evidence that you've seen that would sort of prove that level of intent, the deliberate targeting of civilians?
I mean, a court of law would be looking to the whole constellation of evidence that's available, including, for example, if there is signals intelligence, insiders, etc. I can't discuss what we have been looking at. Much of that does come from intelligence sources. But that's the kind of information that needs to be looked at. But the fact that this was very clearly marked with the word children, it's obviously an essential element of the civilian infrastructure. It's not a military objective that makes a concrete contribution to military activities. And so for those reasons, it appears to have been directly targeted.
So there are things that you can't sort of tell us now because it's intelligence, but that will be submitted for future, potentially for courts in the future.
At this point, it's all being preserved with an eye towards that, yes.
Missy?
Ambassador, just a couple of questions for you. First of all, can you just for, again, to Vivian's point, to explain for the general public how this works, how is responsibility determined in war crimes cases, given that there's a military chain of command? Who is held responsible, the person who pulls the trigger or the person who's the commander-in-chief? I'm wondering if you could shed any light on that. Secondly, will this announcement affect sanctions or travel bans in any way? And third, I think you mentioned the possibility of domestic courts being a venue for pursuing these allegations. Does that mean that the Biden administration is considering filing charges in a domestic court currently? Thank you.
Right. So question number 2, I'll just say I can't really preview any sanctions determination. So that's all I can say for that. Question number 1 was...
question was, how do you determine responsibility in a military chain of command?
And as you mentioned, there is a chain of command when it comes to a military like the Russian military. And doctrinally, we're able to hold responsible under international law those who are directly responsible, those who might be complicit, or otherwise engaged in some sort of a joint criminal enterprise with the perpetrators. The doctrine of superior responsibility allows for commanders to be held responsible for acts committed by their subordinates if they're aware of those acts and they fail to either prevent them in advance or punish them after the fact. So all of those sort of criminal law tools could be used by any court that's able to seize jurisdiction in this particular case.
And then on the domestic courts, yeah.
Right. So, unfortunately, I will say, the U.S. War Crimes Act may be of limited utility in this particular context. It is limited to perpetrators that are U.S. citizens or to victims who are U.S. citizens. So war crimes committed by Russians against Ukrainian citizens would fall outside of the jurisdiction. I know that there are a number of proposals now floating around Congress, and Congress is extremely seized of the imperative of accountability here. And I imagine that those proposals will be looked at very carefully as to whether or not there could be some discrete fixes to the War Crimes Act.
Thanks.
Thank you.
Ambassador, President Biden obviously branded Vladimir Putin himself a war criminal. Then the Secretary of State said that he personally agreed with him. I wonder, does this assessment also include crimes by Vladimir Putin himself? And if not, why not?
Well, we have looked broadly at Russia's forces, and the conclusion and assessment is that Russia's forces are committing war crimes. I think that's consistent with the two prior statements.
But does that mean that he's just not to pick here, but does that mean that he's specifically not included, or does that mean that you can also go after him, as it were?
I think in making that assessment, the Secretary was looking at the entire matrix of information that's available.
But can you go after him on the basis of this assessment? I think a little bit touching on the question that you just answered there.
I think that's a question that's left to a court of law that has appropriate jurisdiction over individuals involved in the conflict.
Maybe the question might be better asked this way. I mean, as Commander-in-Chief of Russian forces who you have just accused or made an assessment that are committing war crimes, is President Putin liable for the actions of people who are under his command?
As I
in the
mentioned,
same way that any Commander-in-Chief of any armed forces would be.
yeah, in response to Missy's question, I mean, there are doctrines under international law and domestic law that are able to reach all the way up the chain of command.
So the answer is yes.
Again, that would depend on a court that has jurisdiction.
Ambassador, a quick final question.
Okay.
How soon do you think you can produce something that can be made public in terms of allegations, charges?
I think it's important to do that. Obviously, we have to do a full assessment of the information that's available to us and make sure that it doesn't compromise any means and methods of collection. But I think keeping the world apprised of what's happening on the ground in Ukraine is extremely important.
Are we going to get something in weeks, months?
I can't predict, sorry.
Thank you.
I'm literally on my second day of the job. So.
Thank you. Thank you.
Thank you.
I'm not going anywhere.
No, I know,
Yes.
but maybe we could get her back, the ambassador back, for some other war crimes related, non-Ukraine related.
I don't want to sign her up for anything just now, but she will have full pressure from me to come back. I very much appreciate
Unfortunately,
that.
this is not just the Ukraine
Yes,
subject.
of course. Well, and that is why we are especially lucky and gratified to have her on board and to have her confirmed just last week. With that, happy to carry on.
Okay, can you tell us anything more than what you said on television this morning about the consular access that you guys were granted to Brittany Griner in Russia?
What I can say, Matt, is to add on to what I said just the other day, that Ambassador Sullivan, as you know, had an encounter at the Ministry of Foreign Affairs. The Ministry of Foreign Affairs conveyed the message that they wanted to send to us. Ambassador Sullivan thought it was important for him to convey a very clear message back to them. And the message he wanted conveyed was the imperative of the Russian Federation upholding their international commitments, including the commitments under the Vienna Convention and the commitment under our bilateral agreement on consular relations, to allow consistent and timely consular access to all U.S. citizen detainees in Russia, including those who are in pretrial detention. And again, this is in compliance with its obligations under the Vienna Convention and under the consular relations bilateral consular convention with the United States. And so we continue to urge that they allow consistent, timely consular access, as I said before, to all U.S. citizens in line with those obligations. We also continue to press for fair and transparent treatment for all U.S. citizen detainees in Russia. When it comes to Brittany Griner, as I did this morning, I can confirm that consular access was granted today, and a consular officer visited Brittany Griner earlier this morning, Eastern time, would have been later in the day, Moscow time. We continue to insist that Russian authorities allow consistent, timely consular access to all U.S. citizen detainees in Russia. The consular officer who visited with Brittany Griner was able to verify that she is doing as well as can be expected under these very difficult circumstances. We'll continue to work very closely with her legal team, with her broader network, to see to it that she is treated fairly and that her rights are respected.
Do you have any more clarity on what charges she actually is facing based on this visit, or was it mainly just kind of a health and welfare?
These consular visits, especially the first one, tends to be a check-in on the individual and his or her welfare and well-being. Obviously, the Russians have spoken publicly to the charges that they have mounted against her. I don't have anything for you on that.
And then just last one, you say that you pressed Ambassador Sullivan and you have pressed for the Russians to give consistent, timely access. It's been more than a month since she's been detained. Do you think that today's visit is in keeping with consistent and timely access?
Heretofore, no. Time will tell whether that posture is changing. In our minds, it is our expectation that this not be a one-off visit. Again, we want timely, consistent access to American detainees in Russia, including those in pretrial detention. That would call for additional visits to Brittany Griner and to other Americans who are detained in Russia. Simon.
I'm not sure whether you would have seen it, but Interfax is reporting that the Russian Foreign Ministry is to expel some U.S. diplomats in retaliation for the U.S. expulsion of Russians from the UN mission. I think that just came on the wire as you started talking, but do you have any response to that?
You're right, I had not seen that. What I will say is what we've said before, is that we believe that ready, open lines of communication are indispensable, especially during times of heightened tension, especially during times of conflict. As you know, for several years now, the Russian Federation has limited our ability to have a fully functioning embassy in Moscow. Our watchword has been parity. We want to see parity between Moscow's embassy operations here in the United States and what we're able to have in Russia. As you've heard, our embassy in Moscow continues to be a locus of coordination and communication with our Russian counterparts. We would not want to see that closed down. It is also true that the restrictions the Russians have placed have been quite burdensome on our embassy operations, and there is not much to give in terms of our ability to continue with a functioning embassy in Moscow if those operations, if there are further personnel limits placed on our embassy in Moscow.
If you wanted to respond, the Wall Street Journal is reporting that the Treasury and this would have involved the State Department as well. There were plans to sanction the Russian oligarch Roman Abramovich, and those were the sanctions ended up not being announced because President Zelensky had requested that of President Biden. Is that something you confirm? And is there any prospect of Abramovich still being sanctioned?
As you heard from Ambassador Van Schok in a very different context, we don't preview sanctions activity. What is true, however, all of you know that President Biden is right now on his way to Brussels. He will carry with him several missions when he meets with our NATO allies, with our G7 partners, with the European Commission as well. One of those tasks will be to ensure that collectively we are doing all we can to hold to account those responsible for this war, for this needless conflict. And so I expect that you will hear from the president and some of his partners additional details on further sanctions that we're prepared to impose on those responsible for this war. But we're just not going to go into specifics today.
In a more general sense, so the reporting here is that Abramovich, had some role or has a potential role as a mediator between the Ukrainians and the Russians. Would you potentially, leave someone out of sanctions if you thought that they could play that kind of role?
I'm not going to weigh in on a hypothetical like that. I will say that there are a number of channels through which our Ukrainian partners and their Russian counterparts can engage in dialogue and diplomacy. A number of our European allies, to include our French allies, our German allies, our Turkish allies, our Israeli partners. Other channels are extant at the moment where that kind of diplomacy can take place. Those are the channels we're focused on. Those are the channels we continue to coordinate closely with our allies and partners on. Yes, Paul. Sure.
On his, the Russian Foreign Ministry has said they called in the ambassador and handed him a list of people to be declared persona non grata. So you have no.
I am hearing this for the first time.
Okay.
Okay. Yes.
I just wanted to follow up on something you mentioned yesterday briefly, and given today's announcements regarding the war crimes and the focus on the situation and the specific attacks in Mariupol. You mentioned yesterday there were reports that you were seeing of people who were being unwillingly moved from Ukraine, specifically from Mariupol, to Russia. Do you believe that those reports are genuinely credible? Do you have any concern or any information on the well-being of Ukrainians that may or may not have been unwillingly moved to Russia? We've seen, several individuals make comments of possible detention or any kind of camp or something like that once they arrive to Russia. So I just wanted to follow up on that briefly.
We've continued to see these reports. We continue to find them very concerning. As I said yesterday, we're continuing to look into them to corroborate these accounts, which have in fact continued to mount. What we need to see in Mariupol and what we need to see throughout Ukraine is humanitarian access. That is to say, passageways so that individuals can voluntarily attempt to reach a safe haven. People can be let out. Humanitarian supplies can be let in. Just about every time we have seen a humanitarian corridor announced, that window, that opening has been slammed shut by additional Russian aggression. Mariupol, as we discussed yesterday at some length, has really been the epicenter of President Putin's brutality, and some of the very incidents that Ambassador Van Schok referenced just several moments ago have, of course, taken place in Mariupol, from the maternity hospital to the theater that appears to have been sheltering children that was very clearly marked. Of course, we can't speak to President Putin's tactics or his strategy, but it is not. It certainly strikes us that Mariupol is a predominantly Russian-speaking city of 450,000 people, as we discussed yesterday. Presumably a city, if you listen to President Putin and those around him, a city where President Putin may have expected his forces to be greeted as anything other than what they actually are, and that is aggressors who are inflicting violence upon a civilian population in a sovereign, independent country. The fact that citizens of Mariupol and throughout Ukraine have mounted such stiff resistance may speak to the level of brutality that the Russian Federation is inflicting on this population. And of course, the great irony of this, if you were to have listened to President Putin before his invasion, to have heard his specious argument that this would be an operation to protect the welfare and the well-being of Russians and Russian-speaking populations throughout Ukraine. We consistently warned prior to this invasion that that would be nothing more than a pretext. And now look at what President Putin and his forces are doing to Mariupol, to a Russian-speaking population. It is a city that has been devastated. The scenes of carnage, the scenes of violence and brutality, they are heart-wrenching. And this is the very people that President Putin purported to want to protect.
Thanks, Ned. I have a quick Ukraine question and then a non-Ukraine question. On the war crimes designation, can you just tell us if there were consultations with the Ukrainian government in advance of this, how those conversations went, any more color or detail you could provide to how it came about?
So this is not the sort of announcement that we would make unilaterally on our own without extensive coordination. I'm not in a position to detail all of that, but our European allies and partners have also spoken to their concerns for the potential war crimes in this context. We've discussed President Putin's brutality and the violence of his forces with our Ukrainian partners as well. So there were extensive consultations before we made this announcement today.
Thanks. And then on my non-Ukraine question, I wanted to turn to Afghanistan. The Taliban restricting girls from going to high school. Obviously, this is in violation of their promises to the U.S. Where do those discussions stand as far as any contact with the Taliban and any efforts that the U.S. might have to try to mitigate the situation or reverse it in some way?
Well, this is something that you've heard our Special Representative for Afghanistan, Tom West, speak to, our Special Envoy for Women and Girls, Rina Amiri, speak to, our Chargé, who is now based in Doha, Ian McCary, speak to as well. Each of them have put out statements in response to this announcement. And we join millions of Afghan families today in expressing deep, deep disappointment and condemnation with the Taliban's decision not to allow women and girls to return to school above grade 6. You have heard this from us before, but education is a human right. It is essential to Afghanistan's economic growth, its basic stability. A country that does not allow more than half of its population to participate is not a country that can achieve any degree of prosperity, stability, safety, security for its people. This is a betrayal of public commitments that the Taliban leadership made to the Afghan people and to the international community. You said it was in contravention of the Taliban's commitments to us. We are most concerned that it is in contravention to the very commitments that the Taliban have made to their own people. They have acknowledged previously that all Afghan citizens have a right to education for the sake, again, of the country's future and for the sake of its relations with the international community. We urge the Taliban to live up to their commitments to their people, to the commitments they have made to the international community as well. In line with that, it is just a fact that today's announcement will have an immediate impact on the Taliban's ability to gain legitimacy and international political support. We've long said that any future government of Afghanistan, international legitimacy, relations with any such future government will be predicated on a number of things. The ability and willingness of that government to live up to the commitments that it has made to its people and to the international community, the commitment to safe passage, the commitment to live up to what it has said vis-a-vis Al-Qaeda and other terrorist groups, but also the human rights that are to be accorded to all of Afghan citizens, its women, its girls, its minorities as well. This is something we'll be watching very closely. Yes, Missy.
So Madeleine Albright's family has just announced that she has died. Do you have anything to say about her death?
So I heard about this just before coming out today. What I can say is that I expect you'll hear more.
Madeleine Albright has died.
I expect you'll hear more from the secretary later today. Of course, the secretary and the president are aboard Air Force One, but they have been apprised of this. I can say that the impact that Secretary Albright, Professor Albright, Dr. Albright, she's known as many titles around here and in Washington and around the world, the impact that she has had on this building is felt every single day in just about every single corridor. A number of our most senior officials, from Secretary Blinken to Deputy Secretary Sherman to our Chief of Staff, Susie George, were lucky enough to call her a boss, but I think the better word is probably mentor. And a number of us have had the great pleasure to have gotten to know Secretary Albright over the years. There are a number of people in this building who continue to work here and to recall very fondly her tenure. Of course, she was a trailblazer as the first female Secretary of State, and quite literally opened doors for a large element of our workforce.
A professor of yours? She was of mine.
I was never lucky enough to. I was never lucky enough to take her class. I was lucky enough to co-teach with her, and those were experiences that were humbling and terrifying at the time, but an experience that is and will be unforgettable. I know that she took so many people under her wing that you have to imagine just how large that wingspan came to be. So It's a really devastating piece of news. I know there are many people in this building who are grieving and who will be grieving today, and our thoughts, of course, are with her family and the many people she touched in this building, in this country, and around the world. And I'm sure we'll have more to say.
Thank you.
Yes, Missy.
With a few questions on Afghanistan. How will the United States, what concrete steps will the United States take in response to the Taliban's decision on girls' education, and how will you balance the need to, or presumably the desire to, make the Taliban government understand that this is not something that you want them to do with the agency of the humanitarian situation. And then secondly, I would just love for you to reflect on the decision to withdraw in light of this, because, you know, there was one of the primary objections from the critics of the decision to withdraw from Afghanistan was that the situation for women and girls would be threatened. And now, you know, there's a significant step forward to having those warnings on that front be fulfilled.
Well, to be very clear, the situation for women and girls has unfortunately been precarious in Afghanistan for far too long. There were gains achieved after the Taliban was wrested from power in 2001 and the years thereafter. But you have to recall that in more recent years, the Taliban made territorial advancements, and by the time the decision was made to disengage militarily from Afghanistan, the Taliban was in control already of large swaths of the country. Now, not having a military presence on the ground in Afghanistan says nothing to our ability to continue to use every appropriate instrument to place leverage on the Taliban. And we have continued and will continue to do that along with the international community. The totality of our relationship with any future government of Afghanistan will be contoured around these very questions. The extent to which the Taliban or any future government lives up to the commitments it has to the international community, but more importantly, the commitments it has to the people of Afghanistan. And again, our focus is on all people of Afghanistan, women, girls, minorities, those who have been historically marginalized within Afghan society. So right now, we are continuing to work very closely with our partners in Doha, here and around the world, to see to it that our approach to the Taliban, especially in light of these lamentable decisions, is calibrated appropriately. We have engaged with the Taliban on these very questions. Rina Amiri, Tom West, and others, Ian McCrary, have continued to have discussions with the Taliban together in many cases with other Western partners and other international partners. And the Taliban will come to recognize, if they don't already, that when the United States acts together with our allies and partners, when we bring collectively the economic, the financial, the other forms of leverage that together we can muster, that this is something that we will continue to insist on.
Just to press you a little bit more on that, what specific things will the Biden administration do, can you do? Because, you know, the attempts so far to use the leverage that the United States has in terms of its, you know, political clout and its control of the reserves and all of that, and aid funds haven't stopped it from doing this. So I'm just hoping you can help people understand what is within the power of the U.S. government in this current situation.
So I would speak to it in two directions. The first is the humanitarian support that we have and will continue to provide to the people of Afghanistan. And as you know, we have, even in the past year, donated hundreds of millions of dollars to the people of Afghanistan, and that includes for elements like education, for food, shelter, basic necessities and commodities as well. These funds have not and will not pass through the Taliban, and that is done very intentionally. This goes back to the point I was making before, that any future government, if it is to have a relationship with the international community, a relationship from which it can accrue legitimacy, from which it can accrue the material resources that it will need to achieve a functioning and stable government. It will be incumbent on any such future government or any such movement, whether that's a Taliban or otherwise, to adhere to its international commitments. And to us, the commitments that the Taliban have made publicly to the international community and to the people of Afghanistan will continue to be central as we determine how we can best support the people of Afghanistan with our continued humanitarian assistance. And we've continued to be the humanitarian leader in supporting the Afghan people, but then how we can continue, and again, we'll do this together with our international partners, continue to pressure the Taliban to reverse these wrong-headed decisions and to live up to the commitments they've made.
Okay, last question on this. Do you have any reason to think that they care enough about having a relationship with the international community? Because this was a specific item that was put forward for them, as a condition, and they've spurned it, within the first year of being in power. Why would you think that they would, set aside these other things if they are doing, if they're banning girls from school, with the knowledge that could prevent them from having these fuller global engagements?
This is about much more than an international relationship. This is about the ability of a government to garner what would come with legitimacy from the international community. This is about material input. It is about the ability of that government to sustain itself, to support itself. Prior to the fall of the previous Afghan government, something like 70% of public expenditures of the prior government were financed by the international community. No future government will be able to secure its position and to provide the kind of services that it will need to do for the people of Afghanistan if it does not have a functioning relationship with the international community. And we have made very clear that when it comes to the United States and when it comes to our partners with whom we've continued to coordinate very closely and act in unison, that we will be looking to these key metrics. And at the top of that list will be the Taliban's ability and willingness to live up to the commitments it has made publicly to its own people and to us. Sure.
The National Security Advisor said yesterday that a role Russia played in the JCPOA was accepting enhanced uranium from Iran's stockpile to keep them under the breakout threshold. Is it fair to expect Russia to play the same role if there's a return to mutual compliance?
Again, we are not there yet. This is something that, in terms of a mutual return to compliance, we've seen the significant progress that had been achieved in recent weeks. But as you've heard from us in recent days, an agreement is neither imminent nor certain. We are preparing for both scenarios. That is to say, a scenario in which we have a mutual return to compliance with the JCPOA, and in which the original members of the JCPOA, the P5+1, would be involved in that very arrangement that would once again reimpose stringent, verifiable, permanent limits on Iran's ability to ever obtain a nuclear weapon, and a scenario in which we do not have a JCPOA, but we are in which we will be equally committed to the president's commitment that Iran will never be allowed to acquire a nuclear weapon.
Jake Sullivan said that role was a practical one. Does the State Department still believe that would be a practical role for Russia to play?
Would it be a practical role for Russia to play the same role that it did in the JCPOA prior to the decision to withdraw from it, essentially to accept and to pay for the highly enriched uranium to get it out of Iran's hands so that Iran cannot obtain a nuclear weapon? I think that's a role we'd be willing to entertain. Yes.
Just following up on the president's call with Xi Jinping last week, the U.S. is obviously concerned about China supporting Russia, and so the president laid out consequences if China provided material support to Russia. My question is, since the call, has the U.S. seen any indication of China's willingness to support Russia Or conversely, have you seen any indication that might dispel those concerns?
The National Security Advisor also spoke to this yesterday. He made the point, as we did in the aftermath of that call and just before it, that we will be watching closely that any effort on the part of the PRC to help Russia escape the worst consequences of the economic and financial measures that the international community has imposed on it would be of great concern and would be met with severe implications. As the National Security Advisor said yesterday, we haven't seen any indication that the PRC has provided that support.
Just to follow up, Secretary General Stoltenberg today in his press conference said that China has provided Russia with political support by spreading lies and disinformation, and said during this week's meetings in NATO would be discussing China's role. Would the U.S. be willing to impose any of those consequences for political support, not material support?
Well, it has not been lost on us that the PRC has continued to spout some of the most egregious disinformation, the patently false lies that have, in the first instance, come from Moscow, including about various chemical weapons and biological weapons programs. That is something that is irresponsible. It is irresponsible for any country to do, whether that is Russia, whether that is the PRC, or any other country around the world. It's something that we take great umbrage at, and it is something that we are watching very closely. Now, look, the PRC and Russia have a relationship that is distinct, certainly, from the relationship that we have with Russia, or that most countries around the world have with Russia. It is not for us to tell any country how its relationship with Russia or the PRC or any other country, for that matter, must look. But it is for us to lay out very clearly the implications on decisions that would have a bearing on our national security, on the safety and security of our allies and partners, including our NATO allies. Yes, final question.
Can I just clarify? So obviously today on the war crimes designation, this is not the State Department or the US government calling Putin a war crime. That still remains the personal opinions of the President and the Secretary of State. Is that something, though, that you rule out? Is there a mechanism by which the US would brand him a war criminal? And I've got a little follow-up after that.
Well, you're correct that this is, as you've heard from the Secretary today, our assessment that Russia's forces have committed war crimes. Now, the United States government is not the only body that is investigating reports of potential war crimes. We are supporting investigative mechanisms around the world, including the Commission of Inquiry at the UN that we helped to establish, the 44-member strong OSCE-led effort that's investigating this, Ukraine's own domestic mechanism to look into the possibility of war crimes. And it is not for us to say how any of these investigative efforts, whether our own or on the part of the international community, where and how they might end. We will all be watching very closely. We will all be documenting, and we'll all be sharing, as appropriate, the evidence that we accumulate. And ultimately, decisions about culpability, decisions about potential war crimes, it will be driven by that evidence and its applicability against what's clearly spelled out in international humanitarian law.
Just separately, Jake Sullivan said to us yesterday that one of the aims of the visit was to come up with, I'm not directly quoting him, but essentially a unified response between America and the West as to what you might do if nuclear, chemical, biological weapons were used. Can we assume that that would be a red line beyond which we would see some form of direct military response?
You can assume, as the President has said, that any use of chemical weapons would elicit a strong response from the United States and our partners and allies.
What does that mean, though?
Again, you can assume precisely what the President has said, that it would be a strong response from our partners and allies. We've tried to be very clear about the gravity of the use of any such chemical weapons. These are agents that should never be employed, and certainly not on the battlefield as we are concerned Russia might. So we've wanted to be very clear together with our allies and partners, and you can imagine that the president will be discussing this with his partners in Brussels in the coming days, that there would be a strong response from the international community were this to come to pass.
You won't say whether that be military or not.
Military response?
We will leave it as a strong response. Thank you very much.
I want to shift gears now to the war in Ukraine, namely the economic implications of the Western sanctions imposed on Russia. It's continuing to grip companies there and companies that have exposure. And I want to show you in our chart of the day, this coming from S&P Global Market Intelligence. It shows you the risk of default rising for 22 Russian companies that S&P looked at. These are companies that are listed primarily on international stock exchanges, like, for example, here in the United States or in the United Kingdom. And just over the last month.
All right, ladies and gentlemen, this is the Stock Market Live with LCAOD. And yeah, looks like that State Department briefing is over, and we're starting back live here with Supreme Court confirmation hearing. Let's tune in here. SPA's trying to fight back to VWAP here right now. That's what's going on. Looks like someone brought the dip here at 444 on the bottom here on the SPA. And the VIX is coming back down here at $23.32. So pay attention, you guys. Stay cautious.
Working their way through the courts, and I'm not able to comment on them.
Okay, if I can change my gender, if I can be a woman, and then an hour later, if I decide I'm not a woman anymore, I guess I would lose Article 3 standing. Tell me, does that same principle apply to other protected characteristics? For example, I'm an Hispanic man. Could I decide I was an Asian man? Would I have the ability to be an Asian man and challenge Harvard's discrimination because I made that decision?
Senator, I'm not able to answer your question. You're asking me about hypotheticals and
I'm asking you how you would assess standing if I came in and said I have decided I identify as an Asian man.
I would assess standing the way I assess other legal issues, which is to listen to the arguments made by the parties, consider the relevant precedents, and the constitutional principles involved, and make a determination.
Okay, let's go back to your favorite topic of this hearing, which is the criminal law cases you had as a district judge, and in particular the cases involving child pornography. Now, your defenders, both on the Democratic side of the dais and also in the press, have suggested that the criticism that has been raised has been somehow cherry-picked, that it's only some specific examples. So I'm going to give you an opportunity to discuss each and every case you've had. Because looking at your cases, and I've now examined all of the child porn cases you've had as a federal district judge, there is a very consistent pattern. So let's start, and by the way, I'm excluding the cases. So Senator Durbin and Senator Coons focused on the Nickerson case, the Fife case, the Nguyen case, and the Hilly case. I'm excluding those because those are not child porn cases. Those are actual sexual assault of a child, which is markedly different. And I will concede when you're dealing with sexual assault, you have been willing to impose stricter penalties. So let's focus on actual child pornography cases. And let's go through each of them, because if it's right that we're cherry picking, then you should be able to explain quite powerfully. Now, your justification is that you're following the statute, and as you know, 18 USC section 3553 lays out the factors that as a district judge you had to consider in sentencing. And let's start with the Hess case, United States versus Hess. Now, in that case, a man sent 6 pictures of a prepubescent girl that he claimed was his daughter to an undercover law enforcement officer. Officers found over 600 images of child pornography, including images of sexual acts being performed on prepubescent children. The defendant pled guilty, and I believe in all of these cases the defendant pled guilty. So there's no question about guilt. They came in and pled guilty in your courtroom. The charge carried a mandatory minimum sentence of 5 years and a mandatory maximum sentence of 20 years. The sentencing guidelines recommended 151 to 188 months sentence. The government, as part of a plea deal, agreed to argue for 60 months, but didn't agree that that would be the sentence, simply that they would advocate it. And you, in turn, sentenced Hess to 60 months. So, under the terms of the statute, why did you choose to sentence Hess to the absolute lowest possible sentence you were allowed to sentence under law?
Thank you, Senator. I have spoken at length throughout this hearing about these cases. I've said what I'm going to say, which is I've taken every case seriously. These are
Do you have anything to
very
say about the Hess case?
horrible
I'm asking you specifically
crimes,
about the Hess
and
case.
I've taken every case seriously.
So you're not going to answer that?
These are very horrible crimes, as was that one. And as a mother, having to look at these pictures, having to follow Congress's directive, having to listen to recommendations like the government in that case, which argued for 60 months, I imposed the sentence that I believed was the sentence that was required by law.
So I believe you, and I've read your sentencing hearing in each one of these cases for which we have transcripts, and there are several of which we don't have transcripts. So in each of these cases, you read from the same script. So in each of these cases, you say that the distribution of child pornography is an extremely serious federal crime. And you point out that the crime involves people who are taking pictures and videos of real children while the children are being sexually abused. In Hess, you pointed out that he had hundreds of images of children in sexually compromised position. Some of them engage in sadomasochistic acts. All of this I'm reading from you on the bench. And most importantly, the children in these pictures are not knowing and willing participants in the degrading conduct that was being depicted. They were being forced by someone off screen to commit unspeakable acts of sexual violence for the pleasure of the people filming them and for the gratification of people everywhere. And what concerns me is that many of those people have absolutely no shred of empathy for what that conduct does for the children who were being abused in this way. And you read this script in every one of these cases. So you talk about that these are terrible, terrible crimes. But you also, and in Hess, you said, I have to say that what I found particularly disturbing about your offense was that, quote, you apparently concocted a story about having photographed your own daughter, who you purportedly were willing to take pictures of to trade with other people. I know from your comments and from those who know you that you are unlikely to ever harm a child, which I find remarkable that you've got a child predator in your court who says, I'm unlikely to harm a child. And you say, well, you told me that, so clearly you're unlikely. But you say, but in the context of the crime, you represented that you would. That in and of itself is astonishing. So you talk about it as astonishing. You nonetheless sentenced him to the very lowest possible sentence allowed under law. And what's striking is in these cases, and half of them in 5, you sentenced the defendant to the absolute lowest sentence under law. Let's look at another case. Let's look at United States versus Chazen. Now, Chazen is a particularly nasty case. In Chazen, the defendant was accessed a Dropbox that contained 35 videos and 13 partially downloaded files of prepubescent minor females engaging in sexually explicit conduct. At least 3 of the instances of prepubescent female children were engaged in sexual activity with adult men. The images included the sexual abuse of children, including those as young as toddlers. And several of these cases that you had involved the sexual abuse of toddlers, which is truly horrifying. In this instance, Chazen pleaded guilty. The guidelines recommended a sentence of 78 to 97 months. The prosecution argued that should be what the sentence was. And you sentenced Chazen to just 28 months. Why did you sentence someone who had child pornography of toddlers being sexually abused to 28 months, 64% below what the prosecutors asked for?
Thank you, Senator. You've picked out, I don't know, 7, 8 cases. I've sentenced more than 100 people.
But not to child pornography.
And in
These
every
are your child
case,
porn cases.
in every case, Senator, I look at the evidence. I look at the recommendations of not just the government, because my duty as a judge is to consider all of the arguments that are made in a case. I look at the evidence. I talk to the defendants about the harms that they have engaged in. Many of these defendants are people who
Okay, Judge, with respect, you're not answering my question. You're right. You talked to them about the harms. Let me read you again from what you said at the bench. You said in this instance, with Mr. Chazen, you said among the defendants nationwide who received a below guideline sentence on the basis of a downward variance as opposed to a departure, the average sentences ranged from 84 to 92 months. So that's what you lay out as the average. Our Democratic colleagues say, well, other federal judges sentence below the guidelines. That is true. A number of federal judges do. Our Democratic colleagues have not pointed to a single federal judge in the country who 100% of the time sentences child porn defendants to markedly below what the prosecution has recommended, unless you have a mandatory minimum and no ability to do so. In this case, you say comparable defendants are sentenced to 84 to 92 months. Sentencing guidelines by statute require you to have similarly situated defendants sentenced to similar sentences, but you don't sentence Chazen to 84 to 92 months. You sentenced him to 28 months. Why?
Senator, I've said what I'm going to say about these cases. No one case can stand in for a judge's entire record.
Okay, but I'm discussing
And
every one of the cases. So
I
if you're
understand
not
that.
going to explain it, then I'm
Senator,
gonna-
would you please let her respond?
no, not if she's not going to answer my
Well, if
question.
you're just going to give a speech, then you shouldn't engage in
And
questions.
you are not taking my time. If you want to filibuster, you're welcome to do so, but do it
I
on your
would
own
at least
time.
give you an opportunity to speak, and you should give her an opportunity to respond.
If she wants to answer the question, I asked her why
Please
she
allow
sentenced-
her to answer the
I
question.
asked her why she sentenced Chazen to 28 months when comparable defendants in
So
her
let's
own
hear-
when comparable defendants in
So
her
let's
own
hear the
words
answer.
were sentenced to substantially higher, and she said she's not going to answer. Did you? I mean, I would welcome your answer, please.
Senator, I didn't say I'm not going to answer.
Okay, well
I
then
said
please
my
tell us
answer.
in this facts, in this case, Chazen, why did you sentence him to just 28 months?
Senator, you're looking at the record. I don't have the record here. What I will say is that in every case, I looked at the recommendations of not only the government, but also the probation office, the defendant, the record, the evidence. I took into account the seriousness of the offense. And
By the way, you know, one of the
ruled.
striking things in Chazen, the prosecutor comes in front of you and says, this is the prosecutor's argument at this point, and the prosecutor says, I understand from my experience before Your Honor's objection, policy objections to the 2G2.2 sentencing guidelines. And he goes on to say, however, in this case in particular, the 4-point specific offense characteristic is justified because it contains sadomasochistic images of infants and toddlers. I'm trying to understand how you see someone that possesses images of infants and toddlers being sexually violated and you sentence them to 64% below what the prosecutor is asking for. You don't provide a justification other than a generic concern that the guidelines are too high. You don't provide a justification as required by statute. So I'm asking you to take the opportunity to explain to this committee and the American people why in 100% of the cases, you have people with vile crimes, and you have language saying they're vile crimes. But then you sentence them to very, very low sentences. And why do you consistently 100% of the time choose to do that?
Senator, no one case can stand in for a judge's entire sentencing record. I've sentenced more than 100 people. You have 8 or 9 cases in that chart.
Okay, Judge, you said that before. These are the 8 or 9 child porn cases. I will say, to correct the record,
I just say to the judge, there's no point in responding. He's going to interrupt you.
Thank you.
Look, I appreciate the chairman trying to filibuster, and if you don't like your witness's answers, you're welcome to provide your own. She is declining to answer the question, and Chairman Durbin, if you want to join her on the bench, you can. But Chairman Durbin,
my job is to make
Chairman
sure
Durbin, I'm not interrupting your questioning.
I'm asking you to give her a chance to answer.
But she's consistently said she's not going to answer. I want to clarify for the record, by the way, the case I was discussing was Cooper and not Chazen. But Chazen is, the case that I was reading from your transcript was Cooper, but Chazen, all right, let's get to Chazen. I pulled the wrong tab. Chazen is equally horrifying, and you say in Chazen, this is something Senator Graham asked you. So the guidelines lay out different enhancements, and you say repeatedly, and this is true in all your cases, you say you disagree with the guidelines, you think they're wrong. And the 2 guidelines you disagree with is, one, there's an enhancement for use of a computer, and you say the world has changed, and now all of these are on a computer. And I understand that. I don't agree with you, but I understand that. That is a understandable thing to say. But the second thing you say over and over again is there's an enhancement for the number of images. And you say repeatedly, for example, in Chazen, you say, whatever the state of the law and technology at the time of the guidelines were first adapted, neither the use of the computer nor the number of images are especially aggravating factors today. Now, I find that bizarre. And you say it in every case. You say the number of images, it's not an aggravating factor, it doesn't matter, and you won't apply the enhancement. Do you really believe that a predator that has hundreds or thousands of images of hundreds or thousands of children being sexually violated has not committed an offense that is more serious than someone that has a single picture of a single child? A single picture of a single child is horrifying, but hundreds of children that have been violated, do you really believe that is not a more serious offense?
Senator, I did not have any cases involving hundreds of thousands of pictures.
No, I said hundreds or thousands. You had cases involving hundreds, and you had cases involving thousands. You're right, you didn't have hundreds of thousands.
And I also applied an enhancement, just not to the degree of the guidelines.
You're right, it's a 5-point enhancement under the guidelines. You provide 2.
Yes, so not 0,
Okay,
not,
you're right,
not the
but-
suggestion
But,
that I
but
did.
are you suggesting the number of images doesn't matter? Because you say it in court over and over again that the number of images doesn't reflect that it's a more serious crime. Do you really believe that?
Senator, as I said to Senator Graham, the court is taking into account a number of circumstances. The commission has done a report about the operation of the guidelines, which enhancements actually reflect different levels of culpability with
So
respect.
let me ask you this, Judge. You've said the purpose of sentencing is to distinguish between crimes that are not as serious from truly egregious crimes. Is that right?
No, Senator.
So what is the purpose of sentencing if it's not to distinguish from less serious crimes from truly egregious crimes?
It is to assign proportional punishment. It is to do justice in cases where you have defendants who are convicted of the same conduct, but have differing levels of culpability.
Well, I will point out that you have a pattern. It doesn't matter how egregious the case is. Senator Hawley talked about the Hawkins case where you had an 18-year-old with pictures of boys as young as 8 being sexually assaulted and raped, and you sentenced him to just 3 months in jail. And I will point out the Stewart case, the last one on this list because we're running out of time. The Stewart case, you describe that he had over 6,700 images and videos. So that's a lot, 6,700. That's a lot of kids being sexually assaulted. You have taken over a minute of my time, Mr. Chairman.
Okay.
So
You've been given extra time. You usually ask for it. You're given it.
okay, I know you want to interrupt. I know you don't
I
like
just
this
want you
line
to
of
play by
question.
the rules.
I know you like to interrupt, but
I like
you've
you
consumed a
to play by the
substantial
rules.
question of my time of my questioning, and I'm going to ask my questions, and you can, if you
Senator-
want to testify, you're welcome to.
Senator,
Judge,
you play by the same rules as
in
every
the
other senator.
in the Stewart case, you said from the bench, thus, although this is not necessarily an atypical case, your child pornography possession crime was egregious in the court's view. Okay, so this is a bad one. If you're actually sentencing defendants, you said this was egregious. What did you sentence Stewart for? The guidelines said 97, 121 months. Prosecutor said 97 months. You said it's egregious. 6,700 images. You come in with 57
Time
months.
has expired.
Why
Senators
did
used
you
2
sentence
minutes
him to
over the
just
allotted.
57 months in the Stewart case? Do you want to address that? Because you're claiming it's cherry picking. In fact, you're welcome to explain any of these cases, but let's take the Stewart case.
Senator
Why
Coons,
did you sentence him for half the amount?
you're not recognized, Senator. Senator
If you,
Coons,
do you not want her to answer that question?
you wouldn't allow her any.
Mr. Chairman, she may answer the question. I've asked her why she sentenced Stewart.
You've
an
gone over the
egregious-
time, Senator, by 2 minutes.
Why she
and a
said,
half.
because you've interrupted me for 2 minutes, Mr. Chairman. Will you allow her to answer the question, or do you not want the American people to hear why, with someone she described as an
There
egregious
comes a point, Senator, where you get a little bit.
Chairman Durbin, will you allow her to answer the question?
You won't allow her to answer.
I will happily allow her to. The question is
Senator
why
Coons, you may
thank you
proceed.
sentence Stewart, an egregious child pornography possessor,
So,
to
Judge Jackson.
half of the amount
Please, Senator.
requested by the prosecutor.
Please, Senator.
Will you allow her to answer the question, Chairman Durbin?
Senator Coons.
Why are you not allowing her to answer the question? There's
You're
not
over
another
the time
senator
by
here
2
that
and a
you've
half.
not allowed her to answer the question.
You're finished.
I'm not asking another question, but allow her to answer the question, Chairman Durbin.
Thank you, Chairman
Why do you not want the American people to know what happened in the Stewart case or any of these cases? Chairman Durbin, I've never seen the chairman refuse to allow a witness to answer a question. You can bang it as loud as you want.
Well, I can just tell you, at some point, you have to follow the rules.
Okay, will you let her answer the question? You've been interrupting, and by the way, with Senator Graham, it went 10 minutes over. You've
sure
taken
did.
a big chunk of the time. Will you allow her to answer the question?
You've given her.
Why are you afraid of her? She's welcome to answer it right now. Will you let her?
Senator Coons.
Will you let? So no, you don't want her to answer the question?
Senator Coons.
Will you let her answer the question?
Chairman Durbin,
Apparently,
Judge
we're
Jackson.
very afraid of the American people hearing the answer to that question.
we here in the Senate, in this committee today, are in the middle of a policy fight. It's my understanding that across this nation, more than 70% of district court judges who impose sentences in cases such as the ones that have been so vigorously debated here depart downwards from the sentencing guidelines, from the requests of the prosecutors. And as you've explained repeatedly and in detail, that's because a sentencing judge is required to weigh a whole series of factors. How many opinions have you written as a judge, Your Honor?
I've written at least 570 opinions, Senator.
And in how many cases have you imposed sentences as a federal judge?
More than 100 cases.
And across all of those, we've just heard very forcefully assertions made about you and your character and your capabilities and your background, narrowing in on just a few. And I would simply put, for those who are watching and trying to understand what all of this is about, that in an attempt to distract from your broad support, your deep record, your outstanding intellectual and legal credentials, that we are taking what is a policy dispute that should be decided by members of the Senate. If we want to change the sentencing guidelines to make them mandatory rather than advisory, if we want to change the structure within which a federal judge imposes sentences, we could do that. But to demand that you be held accountable for this practice that is nationwide and is years old, I view as an unfair misrepresentation of your record. So if I could, let's go to something that you did as the vice chair of the Sentencing Commission, an important vote that you took in 2014. Because in my view, it shows how fundamentally misguided are the attacks that try to characterize you as someone who, at all costs, will do what you can to help criminal defendants. Let me just lay out the context for a moment. In 2010, Congress, enacting a policy choice,
unanimously passed the Fair Sentencing Act, a bill that reduced the disparity in sentences between crack cocaine and powdered cocaine from 101 to 18 to 1. And the Sentencing Commission unanimously concluded this law meant those currently in prison on crack offenses could seek to shorten their sentences. 4 years later, the commission further concluded that individuals who provided substantial assistance to the government, people who cooperated, who helped out the prosecution, could use this law to shorten their sentence retroactively beyond any break they might have gotten for their cooperation. But you disagreed. In your public remarks at the time, you explained that although, given your prior service as a federal public defender, it might seem logical you'd support this direction, you could not do so because you concluded it was manifestly inconsistent with the law and would create unfair disparities between those previously sentenced cooperators and those sentenced today. Essentially, if I understand your view, it was that the sentence of a cooperator shouldn't be understood to be based on the sentencing ranges modified by the Fair Sentencing Act, but was best understood as a fixed discount of the mandatory minimum that a Fair Sentencing Act had not changed. I know this is technical, but I just wanted to make sure I'm characterizing this correctly before reaching a conclusion. Do I understand the context correctly in which you made this decision?
Yes, Senator, perfectly. It was debate among the commission, one of the very few in which we couldn't reach agreement about the retroactive application of the Fair Sentencing Act reduction.
And so just to finish the framing, the Sentencing Commission, which often decides things unanimously, was sharply divided. And here's who was on each side. You voted to deny relief to cooperators, to deny them a pathway towards reducing their prison sentences. And you were joined by two conservatives well known to us, Judge William Pryor, and now Judge.
All right, we're going to tune into the COVID-19 briefing. It looks like we're about 20 minutes late here, but we're going to tune into this.
Heroes, our essential workers, and our families navigating this COVID world. We're prepared to execute the President's plan. We look forward to working with Congress, our state and local partners, and every responsible American to come out of this pandemic in a better place. Back to you, Jeff.
Thanks, Secretary. I want to outline additional impacts that will occur over the coming weeks and months if Congress does not provide the appropriate level of funding for the continued fight against COVID. Let me start with vaccinations. We have enough supply for the immunocompromised to get a fourth dose. And if authorized in the coming weeks, however, if the science shows that fourth doses are needed for the general population later this year, we will not have the supply necessary to ensure shots are available, free and easy to access for all Americans. Without more funding, we can't procure the necessary vaccine supply to support fourth shots for all Americans. Furthermore, if things change and there's a need for a new vaccine, a new formulation, for example, a variant-specific vaccine, we won't be able to secure doses for the American people, and we won't be able to ensure America is first in line for them. Not having enough vaccines is completely unacceptable, as vaccines have proven to be our single most important tool in protecting Americans. We should be securing additional supply right now. Many other countries are already doing so. In fact, Japan, Vietnam, the Philippines, and Hong Kong have already secured future booster doses. Beyond vaccines, without additional funding, we can't sustain the domestic testing manufacturing capacity we've built over the past year. And because it takes months to ramp back up to rebuild capacity, failure to invest now will leave us with insufficient testing capacity and supply if we see another surge in cases and demand for testing increases once again. That should not be allowed to happen. To summarize, the consequences of congressional inaction are severe and they are immediate. The uninsured fund is winding down. Fewer life-saving monoclonal treatments are being sent to states. Fewer treatments available for the immunocompromised. And we risk not having sufficient vaccine supply or testing capacity. These consequences will only get more significant over time with less treatments, vaccines, and tests for the American people. Congressional inaction also hampers our global response. We all know this virus knows no borders. And leaving large unvaccinated populations worldwide will increase the risk of new deadly variants emerging that could put Americans at risk. Under President Biden's leadership, we've donated 1.2 billion vaccine doses to the world, with more than 500 million doses already delivered to 113 countries. The challenge now is turning these vaccines into vaccinations. But without more funding, we can't extend the support to under-vaccinated countries that they need this year to get shots in arms. The bottom line is we've made tremendous progress across the last 14 months in the fight against COVID. And the president has a plan to sustain and build on this progress and ensure we remain prepared in the face of this very unpredictable virus. But we need Congress to act and provide $22.5 billion in immediate emergency funding so we can execute on the plan, so we can be prepared for whatever comes next. Importantly, those who have been on the front lines, Republican and Democratic governors, hospitals across the country, teachers, and 200 leading public health experts have all called for additional funding for the COVID response. Further congressional inaction will set us back, leave us less prepared, and cost more lives. There's no time to waste. Congress needs to act. With that, let's open it up for questions. Over to you, Kevin.
Thanks, Jeff. We have time for a few questions today, so everybody please keep their questions brief. First, let's go to Sabrina Siddiqui at the Wall Street Journal.
Thank you, as always, for doing the briefing. I just wanted to circle back to the BA.2 variant. Is it your expectation that that will become the dominant strain here in the U.S.? And while cases overall, as you said, are in decline nationally, do you expect that we may still see an Omicron-type surge as we did over the winter? And how are you defining, the community transmission levels in terms of restrictions like masks, to move from low to medium to high? Is it focused just on hospital admissions, or is there a certain threshold or benchmark of cases that would necessitate, for example, bringing back masks? Thank you.
Okay, Dr. Walensky.
Yeah, thank you, Sabrina. So we do anticipate, and we have seen over the last 8 weeks as we've been following BA.2 here, that it is representing an increasing proportion of the cases that we have. Now, of course, that is a smaller number of cases, but we do anticipate over the weeks that we may see it become the predominant variant here, as it has already in the Northeast. In terms of how we're defining and what I will say, though, is back to what Jeff and I just spoke about. Should we see more BA.2, we actually have the tools. While it is slightly more transmissible than the original Omicron, our vaccines work, our boosters work, and it does not indicate more severe disease than the original Omicron. So those tools are going to be key in protecting ourselves and our communities against BA.2. In terms of our COVID-19 community metrics, we look at hospitalizations for COVID-19, we look at hospital capacity, and importantly, we also look at cases. So all of those go into the formulation as we use those metrics for future guidance.
Next question, please.
Let's go to Betsy Klein at CNN.
Hey, thanks for taking my question. Given Dr. Fauci's remarks on the consideration of a second booster for adults potentially within the next few weeks, and then your comments, Jeff, that there won't be supply for Americans who aren't seniors or immunocompromised without congressional action, should those Americans expect to pay out of pocket for an extra booster? And will there be vaccine supply for Americans who haven't necessarily had a first, second, or third shot yet and choose to do so in the coming weeks?
Yes, let me make it clear that we do have sufficient current inventory of vaccines, both at states and pharmacies and other access points around the country, and in our central inventory for fourth doses if they're called for this spring for our most vulnerable, including seniors. Where we do not have sufficient doses is later in the year if there's a the science dictates that all Americans should get a booster, or if there's a need for a new formulation of the vaccine, a variant-specific vaccine, for example, then we will not have sufficient supply. In terms of people getting their primary series, their first or second dose, or their first booster, we continue to have sufficient supply in the near term. Next question, please.
Go to Peter Sullivan at the Hill.
Hi, thanks. I wanted to ask on the funding issue. Senator Romney said today that he's expecting a new proposal from Democratic leadership. Sounds like with some new offsets in it. Is the White House involved in that new proposal? And do you feel like you need to engage on the offset question a little more, given that Republican senators still seem to be saying it needs to be offset?
So let me just sort of step back and start with our Hill engagement and how long we've been at this. We've been extensively engaged with Congress for months now. And going back to just after the new year, mid-January, we've been working with members of Congress, Democrats and Republicans, on the funding needs for the COVID response. We've hosted dozens of briefings. We've held more than 36 conference calls, and we've shared more than a dozen funding tables. We've given Congress a full accounting of every dollar that's been spent on the COVID medical response, and a full accounting of the entire American Rescue Plan, which, as you all know, goes well beyond the direct medical needs. We've also provided all the specifics of the planned additional funding, how it'll be deployed against additional purchase of monoclonals and pills and vaccines, as we were just talking about. In total, I brought it with us, we've sent 385 pages of documents and tables to Congress. So let me be very clear. Congress has all the information it needs, and we've been responding to questions for months now. Congress has had plenty of time to act, and time is of the essence, as we heard across the briefing today. With every day that passes, we risk not having the tools we need to fight COVID. And the bottom line is just crystal clear here. The virus is not waiting for Congress to act. With every minute this funding request is stalled, we're losing our ability to protect people and be prepared. In terms of offsets, this is emergency. This is an emergency funding request, and there's not been a need for offsets for an emergency funding request. So we fully believe that Congress should act. They should fund the $22.5 billion, and there should be no need for offsets. Next question, please.
Let's go to Meg Terrell at CNBC.
Well, thanks. I'm wondering if Dr. Fauci or Dr. Walensky could give us some reflections on the news from Moderna today, the results they put out in a press release for kids under 6 for the vaccine. And then also for Jeff or the secretary, how does the funding situation impact the potential vaccine rollout for kids under 6? Is there sufficient supply for them? And if there's not vaccine being paid for in the same way by the government, could that affect kids being able to access vaccines too?
Okay, Dr. Fauci on the Moderna news.
Yeah, thank you for that question, Meg. So the data and the announcement made by Moderna reflects a study done in collaboration with the National Institutes of Health, in which they looked at the effect of a 25 microgram dose of the Moderna product in children within the age group of 6 months up to 6 years, less than 6, but from 6 months up. The primary endpoint of the data was not an efficacy endpoint. It was immunogenicity, to see if that dose in that particular cohort induced a response comparable to the higher dose that you see in the adults. And it met that primary endpoint. Also, the safety profile was quite good. Nothing more or less than you would naturally see with so many other vaccinations. However, there was enough events with regard to infection and enough people in the study that they were able to get an efficacy signal, but the efficacy signal was for infection. And there was not enough or any severity of disease either in the placebo or in the vaccine group to make any determination of the efficacy against severe disease. The efficacy against infection was 44%. Now, that may seem like a low number, but in the era of Omicron, this is actually quite comparable to the efficacy against infection in what we're seeing now with other vaccines. So the data look pretty good right now. They're going to make those data available to the FDA. They will be submitting within a reasonable period of time for an EUA for that particular group, for that particular purpose.
In terms of the supply, we do have that supply secured for kids under the age of 6. So that is good news. And we will be ready operationally if the vaccine and when the vaccine is authorized and recommended. And we'll have those vaccinations available at tens of thousands of locations across the country that parents know and trust. So we do have the supply secured and we will be ready operationally. Next question, please.
Go to Jeff Mason at Reuters.
Thank you. One follow-up on the issue of an additional booster. Isn't it, if I understood this correctly, isn't it possible, Dr. Fauci and Jeff, that there could be approval for everyone in the country to get a 4th booster coming up? And if that is the case, does the United States have enough vaccine for that? And I don't mean later in the fall, Jeff, but I mean like right now, if that comes through. And then one other question for Dr. Lewinsky, could you let us know if the CDC is planning to lift the Title 42 order for all other migrants at the border, and if so, or if not, why or why not? Thank you.
Dr. Fauci.
So Jeff, when we were talking about the possibility in my brief introduction about the possibility of a 4th dose, there's the immediate issue and question, and then there's the longer range question. The longer range question, I think, is what you're referring to, is the advisability or not of a 4th dose of vaccine for the general population. As I mentioned, the FDA will have a VRBPAC meeting on the 6th of April to look at what would be needed with regard to the kind of boost that would be needed, whether it would be variant specific or ancestral strain specific, and for what population might it be needed in the longer range. And in the longer range, we're talking, for example, towards the beginning of the fall, the end of the summer. The situation right now of the data that they are looking at with regard to 4th doses from both companies, from both the companies of the mRNA, the 2 companies for mRNA, Moderna and Pfizer, they're going to be looking at data that have been submitted by those companies to the FDA to make a determination if there will be a subset, perhaps the elderly or others. And as I mentioned, we already know it's already recommended for those with severe immune compromise. So people need to understand the difference between what's being looked at in the next few weeks for the immediate versus the longer range, which would involve the question you also asked of Jeff, if a determination is made that we need to do boosters for everyone, will there be available supply? But Jeff, back to you.
I think you captured it well. I think that we do have a sufficient supply for what we anticipate could be authorized and recommended in the coming weeks, months. However, when you get later in the year, if there is vaccine 4th dose recommended for all Americans, we need the funding to secure enough supply to ensure that we have sufficient doses for all Americans. Over to you, Dr. Walensky.
Yeah, thank you, Jeff. So we last reassessed Title 42 at the end of January. As you recall, that was just around or right after the peak of our Omicron surge, and we had hospital capacity challenges really across the country. That reassessment is due next week again, and we are currently reviewing the data and evaluating it right now, so more soon to come. Thanks.
Next question, please.
A couple more questions. Let's go to Victoria Knight at Kaiser Health, please.
Hey, thanks so much for taking my question. As you guys outlined today, funds are running out to reimburse providers for COVID-related treatment of the uninsured. So what if Congress doesn't act soon? What is the administration's plan for this? And does this mean uninsured people will be left with big bills for COVID care?
Secretary Becerra.
So we're planning to continue to provide the different services that we have put in place over the last year. We're going to continue to divert whatever resources we can to make sure we address the COVID needs of the American public. We'll continue to provide assistance in regions of the country where COVID is still hitting hard and providing medical support where we can. So we'll continue to do everything we can. We'll exhaust every dollar that we have. We'll use every dollar that we can that is flexibly available to continue to provide for the need. And we'll also begin, if Congress continues to delay any additional funding, begin a process of outlining what it would take to continue to offer to the American people those vaccines, those treatments, those therapies that they are coming to rely upon. And so whether it is moving towards allowing Americans to purchase these through other means or secure them through other means, or whether it means getting the support from Congress that allows us to continue to offer those for free, we're going to continue to do what we can to make them available so that every American can remain safe and healthy.
Next question, please.
Last question. Let's go to Gustavo Alegre at NTN 24.
Thank you for this opportunity and for doing this. I have a couple of questions. Dr. Fauci, you mentioned the 4 vaccine shot. However, there are still many Americans who resist being vaccinated, among them millions in the Latino community. Why you think there is still this resistance among Latinos? And if I may, Secretary Becerra, could you send a clear message in Spanish, if possible, to those in this community to highlight the importance of being vaccinated? Gracias.
Dr. Fauci.
Well, for the first part of your question, it is interesting and noteworthy that we have tried to get the equity of availability and implementation of vaccines in minority communities, African Americans, Hispanics. We've done actually quite well in the comparable percentage of non-minorities and minorities who get vaccinated to begin with. One of the things that has not been as successful, and we're trying our very best to counter that, is that boosters are not as much being implemented among minorities, including Hispanics, compared to whites. So we've done very, very well with the equity of the original regimen. We've got to do better when it comes to boosters, and we're trying everything we can to get the message out of why it is so important, because when you look at the data of what boosters do, particularly in the era of Omicron, boosters are extremely important. So that is a deficit that we are trying to correct.
Lo que es importante entender es que en donde nos encontramos hoy es muy diferente de donde nos encontrábamos hace un año o dos. El presidente Biden ha hecho posible que todos en este país, no importa su ingreso, su sitio de vivienda, su estatus, todos tenemos acceso a las vacunas, a las medicinas que se necesitan. En este momento que está mejorando la condición bajo COVID, este es el momento cuando deberíamos de hacer todo lo posible para por fin deshacernos del COVID.
All right, ladies and gentlemen. We got the close approaching here, ladies and gentlemen. We got the close here approaching, ladies and gentlemen. The market is in the red, as you can see here. The Dow is down about 1.9%. The S&P 500 is down about 1.7%. The NASDAQ is down here about 1.12%. The Russell 2000 is down 1.47%. The VIX is up here, you guys, $23.50, up 2.44%. So we're seeing a little bit of a pullback here. I wouldn't be too worried, you guys. This is really, like I said, a buying opportunity here. As long as it can hold right here on the spot 444, that's good support to me. Looks like it bounced off that the other day anyway. Went up, so stocks pulling back here, but not too much. I'm noticing Tesla is back below 1,000 though, you guys. So considering where they were just at, that's a pretty big pullback. I think that's probably the lowest you might get them. They might pull back maybe another $20, $30. That's a maybe. That's a huge maybe. Amazon is down 20 though. They're down 32.77, so below 32.80. They're looking a little shaky over there, but I think if they can retrace that 32.80 level or just stick it here, Amazon will be fine too. But yeah, below 32.80 to me is like they might be playing with a top there, possibly. Might be playing with a top, ladies and gentlemen. But as of right now, 33.50 still look like it's possible to happen too as well. So stay confident. Don't give up. Have some patience, really. We're gonna see. Theta's kicking in though. I would start to be thinking about moving dates there. If targets are not looking like they're gonna get close to their price, look like it's not gonna get close to their target. So yeah, just looking in on some stocks. So we are in the red though. Stocks extend their losses else. Oil prices increase a little. Dow falls about 400 points. That's the headlines here. So that's really where it's at, though. The market is about to close here, ladies and gentlemen, about 15 minutes. I think the earnings today are whack, wiggity, whack, whack, whack. So I'm not even going to tune in to that after the bell today. We're going to close it up right here at 4 p.m. today. Haven't done too much here today with LCAOD. Got a little short, long-term play, as I said, coming in soon here. Expecting it to get on board with the other remaining stocks in the market here. Looks like a laggard to me, a laggard play. Possibility might go. We'll see. We're gonna stay tuned to it. We're gonna hold it too. They got a little, like I said, short, long-term time. They got about 2 weeks. So we're gonna see, man. We're gonna keep that play alive. That's why you see the portfolio. The numbers jumping here today. You see my portfolio down about 4.57% here today. But that ain't really nothing considering the reward that play can be. So keep that in mind, ladies and gentlemen. This is how it works. I'm just really showing you guys how it works here. See, these numbers are rolling here once you start to buy into these companies. Like I said, your money invests for you. You don't have to do anything. Your money works for you. You have to put no physical labor in. It's all mental mind work. It's what they say. I think it's a percentage. They say the market is 10% buy. I want to say, I think it's like 10% sell and 80% hold or something like that. I don't know. It's a saying they say though. Basically, it's just basically saying that it's easy to trade. There's nothing you have to do physically, but line it up, chart your numbers, and do your research and trust. After that, have some belief there. Market is bouncing up here towards the end. We might have a 10-minute read, ladies and gentlemen. SPY's bouncing up here. Still in the red though. VIX is still up here, so just a little bounce here though. Basically, just a little bounce here. Amazon got away from 32.80 quickly right there. You see Tesla might even probably be back above 1,000 right now. Ladies and gentlemen, we're about to close here in 15 minutes. This is the Stock Market Live with LCAOD. We've been live here. We missed 1 hour today. Ooh, but like I said, I apologize. It was due to some business there, some consultation I had to go over with. So hope you guys ain't tripping about that little 1 hour, man. You know what I'm saying? I'm gonna still stick to my quote. When you're late, you're on time. When you're on time, you're late. That is a quote from, you know the movie? Send it in the Discord if you know that movie. If the people who don't know across the country, I'm gonna tell you it's Drumline. Go look it up. I just told you so. I wasn't talking professional. Quote from Drumline, man. It's a really good movie. Devin! But yeah, ladies and gentlemen, this is the Stock Market Live with LCAOD. Supreme Court confirmation hearing is still going on here. We're going to stop it right here at 4, even though if they're still going. Can't stick around that long with these people. I have some things I got to do. Business company will be closed. Market will be closed anyway, so day will be over with. But they still talking to her. I hope this the last day. Hope they're giving their sister a break, man, because she needed. They've been talking her head off for 3 days. You seen one of those senators, I think it was named as Ted Cruz. He tried to put some pressure on her. And yeah, man, He showed his true colors there. He got exposed himself. Yeah. So it is what it is, though. He was talking about her cases, though. She might have got exposed a little bit too, but whatever. They fight. This is what it's about. Politics. It makes the numbers move. But ladies and gentlemen, let's tune in. Like I said, we're gonna tune into the close here right now. Then we're gonna wrap it up, man. But it's been an overall chill day. Bears had momentum all day, man. But it's a bull market now, ladies and gentlemen. It's a bull market now, ladies and gentlemen. If you do not know what a bull market is, go read my cover. Ladies and gentlemen, like, share, subscribe to my channel. If you could, follow me on Facebook, Devin L. Parks. If you could, follow me on Instagram, Let Cash Accumulate Over Days. Follow my website, www.com. Let Cash Accumulate Over Days. I think that's right. Some of y'all had to check that. I think that's right, though. www.letcashaccumulateoverdays.com. Yeah, that's right. I got it. I remember. So that's what it is. Y'all check that out. If you want to get signed up, man, hit me. Hit me in the DMs. If you know me locally, you see me. Chop it up with me. You know what I'm saying? Don't be a stranger to the community. We all getting money out here, as you can see. Everything's fine. But yeah, ladies and gentlemen, let's tune in here. We got about, 10, 12 minutes left here. The market's about to close. Start wrapping in them peaks there. Like I said, earnings are whack, wiggity whack here. We're not even going to talk about it. NIO reports tomorrow after the bell. We're going to talk about that. But other than that, nothing. Don't waste your time, I'm telling you.
I'm not a lawyer, but I think you took a lot of us to law school yesterday in ways that were helpful. And in particular, you walked us through some different schools of constitutional and statutory interpretation in ways that I think were good for the committee, we're good for the court, and we're good for the public more broadly. So I guess I would ask you,
Thank you,
if you
Senator.
could take us
I
to law
am
school one more.
not mostly familiar with the Supreme Court's precedents in this area. It's been a while now that the Supreme Court has determined that the 14th Amendment, which guarantees due process, includes a substantive component in addition to procedure. The term due process, one would think, is just about the procedures that the government has to afford you before it affects your life, liberty, or property. But the Supreme Court has also said that that protection extends to certain personal, individual rights that relate to dignity and autonomy, and that are deeply rooted in our nation's history and traditions, or implicit in the concept of ordered liberty. And the kinds of things the court has recognized pursuant to that line of jurisprudence are things like marriage, interracial marriage, the access to contraception, a woman's right to terminate her pregnancy, abortion, pursuant to or subject to the framework established in Roe and Casey, travel, the child rearing, the ability to direct your children. Those are some of the rights that have been recognized pursuant to the 14th Amendment due process clause. I'm less familiar with the sort of scholarly debate outside of the Supreme Court's rulings.
So will there be new ones in the future?
Senator, I am not able to forecast. In every case, the Supreme Court is looking at a particular set of circumstances consistent with the Article 3 requirement that the court look only at cases and controversies. So it would depend on what cases came before the court.
So I think that gets at the challenge here that you and I have been going back and forth on over the course of a couple of weeks, because
I get the modesty points about being on the district court, but it seems pretty important to understand what the limits might be as a justice. And so I think this morning, again, you stated that I think the quote was that your judicial philosophy is your methodology. But I think that a judicial philosophy of some kind is necessarily an input into your judicial methodology and into every justice's actual jurisprudence on the court. And that's why I think it's important for us to unpack that, because the philosophies that you've outlined for the committee, again, I think yesterday's back and forth that you and I had on Breyer v. Scalia, is important, and you wouldn't claim any of those philosophies for yourself. And yet I think the philosophies ultimately instruct judges on the sources and the tools they consult, on how they discern intent, on whether the Constitution is protecting specific limited and defined principles or more general values, and whether modern values can be used to infuse our understanding of the Constitution. So again, when you narrated a bit of the debate between Justice Breyer, I know you've got lots of intellectual inputs in life, but you've credited him as a brilliant jurist and role model before. And the Scalia debates, you didn't really tell us who you thought got the better of the argument. And so I think throughout these 2 days, you've focused a lot on what the Supreme Court has said, and I think that is helpful and important. But I've been also trying to get at what you think the limits might be on what Justice Jackson would be constrained by. So I feel like, I believe we still haven't heard your judicial philosophy, and I wish I'd made more progress with you on that. But what we do know on a personal note is that these committee 3 days have been very long, and I want to thank you, and got to have a nice conversation with your parents earlier, your whole family, for what you've endured and for spending time with us, and obviously wish best wishes to you and your family. Thank you, Judge.
Thank you.
One more minute.
Thank you, Senator Sass, and Senator Blumenthal is next.
Thanks, Mr. Chairman. Good afternoon,
Good afternoon.
Judge Jackson. I know your birthday, September 14th.
Yes, sir.
You have the happy coincidence of a birthday with Constance Baker Motley,
Yes, sir.
who just happens to have been born in New Haven, Connecticut.
Ah,
And we're very proud that she is a daughter of New Haven and Connecticut. And she is one of my heroes as well. As you know about her, she was the first Black woman appointed to the federal bench. She is the first Black woman to have argued before the United States Supreme Court. In fact, her record before the court was 10 wins and 0 losses. She was very predominantly responsible for Brown versus Board of Education. Thurgood Marshall got most of the credit, but she did a lot of the work. Probably sounds familiar to you. So why don't you tell us, and maybe tell those folks, particularly women and girls who are watching or listening, why you said at the outset of the hearings here that she was one of those whose shoulders you stood upon as you came here today.
Thank you, Senator. Well, in addition to the fact that we share a birthday, which I discovered when I was in law school and thought, what a happy coincidence in terms of someone who I so admired. And secretly at that point, I was thinking maybe I might want to be a judge. So it was a wonderful, wonderful coincidence. I so admired the fact that she was the first. It's not necessarily easy to be the first, but it is an opportunity to show other people what is possible. When you're the first, it means no one has ever done it before like you, and there may be hundreds, thousands of people who might have wanted that opportunity and thought, I can't do that because there's no one there like me. And so being a trailblazer, whether it's Judge Motley or Justice Marshall or Justice O'Connor. Being a trailblazer is really inspiring, I think, and I was always moved by Judge Motley's experience, and think it may even be part of why I moved in this direction.
Well, it is inspiring. And I hope that your very inspiring story will make it possible for a lot of others to think it not secretly, but say it out loud and aspire to it, because it's what this country needs. And fortunately, President Biden has recognized it in the nominees that he's put before us. And we've tried to work with the great leadership of Senator Durbin to confirm people of real merit, the kind of qualifications in intellect and character and depth and warmth that you bring to us today. I want to talk a little bit about voting rights, because part of the reason why those dreams now are realities is that more people have the right to vote, at least until recently. In fact, there has been a lot of backsliding about turning back the clock on voting rights. The gentleman sitting behind you, Doug Jones, our former colleague, whom we very much respect and admire, wrote a tribute to Vivian Malone Jones, who has a rich story as a civil rights warrior and who succeeded John Lewis as head of the Voter Rights Project. And he said in a speech that Doug Jones wrote in tribute to her as she was inducted posthumously into the Alabama Women's Hall of Fame, I'm quoting, "We can best honor her by acknowledging that while most doors are unlocked today, they are still heavy
All
and
right,
so
ladies
hard
and
to open."
gentlemen, we got 1 minute. Go ahead, lock in, man. Make your final picks, man. If you think the market coming down tomorrow, buy some puts. If you think the market going up tomorrow, buy some calls. The volatility is there to swing. Ladies and gentlemen, be careful. Good luck. Market's coming down right now, though. Dick sell off here towards the end. A little pullback here, 443. Okay. Still above 440, though, so nothing to really be worried about. It's just still a bull market. Unless we break back below 440, it is still a bull market, ladies and gentlemen. Nothing to be worried about. Ding, 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 ding. The market is closed. That's it here today. That is a wrap here. The market closed in the red. Dow closed down 1.27%. S&P 500 closed 1.23. NASDAQ closed 1.32. Russell 2000 closed 1.47. VIX closed up 2.48. So about a 1% down day here. Looks like a discount to me, or could be the beginning of the pullback, steeper pullback. Could be the beginning, or it could be a nice dip for another opportunity here. March Madness kickoff again here, starting back tomorrow, I think. Sweet 16, you guys. So good luck if you're playing the tournament games, ladies and gentlemen. But that's it here today. That's a wrap. We're going to wrap it up here. This season was the Stock Market Live with LCAOD, ladies and gentlemen. I hope you earned something. I hope you learned something. But we're going to see y'all tomorrow. It was a chill day, man. Very chill day. I like days like that. I really do, man. But we'll see y'all tomorrow, man. Amazon pulled back here, 32.68. So they're back below 33. Looks like a nice little yummy discount there. Let's see where Tesla closed before we leave here. Let's see. Tesla closed. Oh, $9.99 right below 1,000. Ooh, okay. Cool. So, all right, yeah. That's it, ladies and gentlemen. We'll see y'all tomorrow, though. Can't continue to listen to this here. So we'll see y'all tomorrow and see what happens here. Enjoy your evening, ladies and gentlemen. Peace out. This is and was the Stock Market Live with LCAOD. Let cash accumulate over days. That's the best thing you can ever do. See you guys tomorrow.